My Lord, may I mention, my Lord, director the matter to be mentioned as to be mentioned today. Tomorrow is the last date for my Lord for registration. Unfortunately, the matter has no list.
Very well. It will supplementary list will be published. You give notice to your other side. Your other side should be there. What is the matter about?
My Lord, I am a student of BBA, but due to fighting between college and university, I am not my Lord, sitting the examination, fifth semester examination. My Lord directed to give the registration, but till today, my Lord, portal has not been open, my Lord. Tomorrow is the last date, my Lord. That's why my Lord directed the matter has to be mentioned today.
It will appear at 1 o'clock. It will appear. Bring your other side.
Yes, ma'am.
My lord, may I have your lordship's leave to move this matter, my lord? This matter relates to, my lord, issue of OBC in second SLST. My lord, we are waitlisted unreserved candidates. My lord, this it has been done with 17%. If 10% vacancies are removed, my lord, it will go to the unreserved as published in 18th May 2026 by the government, my lord. And my lord, accordingly, the roster has also been changed. It has not yet been done, my lord.
What is happening here? Is the counseling taking
My lord,
place?
counseling has been, my lord, withheld. Counseling has been withheld, but my lord, withholding of counseling has nothing to do.
I understand, but then the urgency diminishes. Right.
Urgency, my lord, it's not that urgent, my lord. It will be moved.
Right.
This is the only thing.
Then you file it in the department, give the number, it will appear in the second SLST bundle.
My lord, on 20, my lord,
21st,
it will, since it is being taken as a whole, there are other issues.
Yes,
my lord,
yes.
if it is taken separately, then my lord.
All right, you file it,
My-
then I'll see.
My lord, may I be permitted to mention item number 348 of your lordship's list for upgradation, my lord? It's a contempt application regarding restoration of electricity at my premises. My lord, the district magistrate had directed the electricity authorities to restore connection. Till date, it has not been restored, my lord. Your lordship had passed the order on 11th of February 2025, my lord. Since then, I am without electricity.
Are you aware who your other side is?
My lord, I shall find it out because once they had appeared in the contempt application.
All right, you find out your other side and bring. Today there is already an early rising. You bring prior to rising, I'll see.
Should I hand over the slip, my lord?
Give the number.
But may I be permitted to mention, my lord, item number 363 of your lordship's list, my lord. This is a contempt application, my lord. On the, my lord, in the writ petition, my lord, this relates to a completely illegal club which is conducting a Durga Puja at Durgapur. Last year, my lord, before the Durga Puja, your lordship had directed the SDO to decide my representation after giving me a notice of hearing. Where that notice of hearing was not given. The notice of hearing I received after the hearing was completed. I protested, an order was passed, yet the club appeared in that proceeding. No illegality was found. When I protested against this, that I've never got any notice, he serves me a notice saying that we never received the copy of the writ petition itself, even though the notice specifically
What
mentioned.
you want?
Now, my lord, we have taken out a contempt application, and the urgency is that, my lord, because of this attitude, the club is proceeding for a Durga Puja even this year also, my lord. Completely unauthorized club, my lord. There are a number of illegalities which we had highlighted.
And who is your other side?
Lord, we have served notice, my lord, upon the other side.
You do not know who is appearing.
My lord, because till date, my lord, on the last occasion, your lordship had directed notice to the alleged contempt. Now that we have done, but we do not know he's appearing for the other side. We can serve the alleged contempt today itself, my lord.
Serve next week, it will appear.
Grateful, my lord.
My lord, may I be permitted to mention online lordship?
Yes.
Lordship recalls on 7th of August, there were 10 matters where NCT communication was challenged, and my lord, I appeared and my name is not appearing. So it gives a bad impression.
Give the number.
Yeah, my junior is there, lordship. She will give the list. 10 different matters, separate orders were passed.
All right.
Grateful, lordship. Yes, lordship, she is in the side. She will give to the court officer the list of 10 matters.
Right.
Grateful, lordship.
We mentioned for correction. Call the list, please.
I beg to appear on behalf of the respondent IIS WPM. My lord may remember I have taken a
scheme contract between the employer-employee.
My lord.
The writ petition will not be maintainable.
My lord, that is my maintainability point.
Argued upon the issue of maintainability.
My lord, my esteemed senior is appearing on the other side. My lord, they have yet not started. On the same principle, my lord, I would like to supplement my submission by using these judgments as well. My lord, I am not wasting my lord's time. The paragraph numbers of my lord.
But then you have to place it. It is not possible to go through this in this manner.
My lord kindly
What
allows.
do you, yes,
If my lord kindly allows me.
ঠিক আছে
Yes. My lord, kindly first take the judgment of the coordinate bench 2024 SCC Online Calcutta 11902.
yes.
My lord, paragraph,
Coordinate bench, division bench.
my lord, division bench. I apologize, my lord. I apologize. My lord, 18D, internal page number 11.
Yes.
Even if it be perceived that imparting education by private unaided the school is a public duty within the expanded expression of the term, an employee of a non-teaching staff engaged by the school for the purpose of its administration internal. My lord, 18C, I seriously apologize.
Yes.
18. It must be consequently held that while a body may be discharging a public function or performing a public duty, and thus its action becoming amenable to judicial review by a constitutional court, its employees would not have the right to invoke the powers of the High Court conferred by Article 226 in respect of matter relating to service where they are not governed or controlled by the statutory provisions.
This is the paragraphs taken from the Supreme
Paragraph
Court.
taken from by the St. Mary's file. Paragraph taken from St. Mary's.
Yes.
So, and my lord, next. 2015 6 SCR 1042 Joshi Technologies. My lord, paragraph number patata bol patata 68 66 768. My lord, page number 1102, the page marking, paragraph number 68.
Yes.
68. 68A, my lord, the next page, 68A. The court may not examine the issue unless the action had some public law character attached to it. Then, my lord, 69, 7, 8, and 9. Writ can be issued where there is executive action unsupported by law, or even in respect of a corporation there is denial of equality before law or equal protection of law, if it can be shown that action of the public authorities was without giving any hearing and violation of principle of natural justice, after holding that action could not have been taken without observing principles of natural justice. Then, if the contract between private party and the state instrumentality and or agency is under the realm of private law and there is no element of public law, the normal course for the aggrieved party is to invoke the remedies provided under ordinary civil law rather than approaching the High Court under Article 226 of the Constitution of India and invoking the extraordinary jurisdiction. Then, my lord, the public law and private law principle is discussed in Roman 9.
Yes.
And my lord, the last judgment, 2024, volume 15, Supreme Court cases 461. My lord, this judgment, it is something like a literature review. The judgment, it, my lords, analyzes the evolution of concept of judicial review of our honorable courts over time. My lord, this starts from paragraph number 35, internal page number 29.
Yes.
Over the years, the scope of
Then
judicial...
you have mentioned a lot of paragraphs on top, I can see. Which one would you like to rely on?
My lord, I will, if my lord kindly allows, I would like to place all the paragraphs because the law where it started, then the law how it changes and ultimate conclusion. This is how the judgment proceeds. The conclusion, my lord, I would,
All right, place it what you were placing.
my lord, grateful, my lord.
Points for determination, I can see page 489.
Page number 29, page 489, in my lord.
At the top, points for determination.
For determination. G, analysis. Scope of judicial review of the actions of the state in matters relating to contract tender under writ jurisdiction. Earlier position of law and misconception of the state as a large C. Over the years, my lord, paragraph number 35, over the years, the scope of judicial review and the extent to which a court can interfere in disputes arising out of contract or tenders has been a significant development.
This is
Mark-
neither a contract nor a tender matter.
My lord, my submission was that the payment of VRS, it is a matter of contract. I had placed judgments regarding the payment of VRS. It is a matter of private contract between the employer and employee without any statutory backing. That was my submission on the earlier date, and I had placed judgments to that effect. So that is why I am saying, my lord, subject to correction, that if the service condition is not governed by any statutory force or there is no statutory backing, then, my lord, the employment contract, even if they have a good case, their remedy does not lie before the writ court, my lord. 36, my lord, earlier the position of law was that any dispute arising out of a contract entered into the state or its instrumentalities could not be adjudicated by the court under its jurisdiction. My lord, I am, will be placing very shortly only the relevant lines. Then, my lord, paragraph 40. Thus, for a period of time, the courts recognized that there was a clear bright line distinction between when a state or instrumentalities could be said to be acting in its executive capacity, when it could be said to be acting in its private capacity, with the existence of a contractual relation inter se parties being determinative factor. Wherever there was a contract, the state's relation and all its actions were said to be within the field of contract, within the realm of private law, and the courts would resile from interfering with the same under the writ jurisdiction or embarking upon a judicial review of such actions. Then, my lord, paragraph number 42, it says that this was a simplistic approach, and this simplistic approach led some problem on the part of the state. Then, paragraph number 44. Before proceeding further to discuss how the scope of judicial review came to evolve, we would like to refer the observation made in MC Mehta. Then, my lord, MC Mehta is quoted. Then, paragraph number 46. The interplay between judicial review and administrative discretion has been a dynamic process, as new challenge and complexities kept on arising before the court as regards the state's action and governance. It continued to refine its approach. This ongoing dialogue between the courts and the executive branch contributed to the development of a more accountable and transparent administrative framework, paving the way for exercise of judicial review, even in the realm of contractual disputes, to achieve a fine balance between the efficiency and fairness in policy decision on the one hand, and the rights of individuals and overall public interest on the other. So a door which was closed, this was getting gradually opened. Then, my lord, kindly takes paragraph number 50. It quotes Srilekha Vidyarthi. Then, paragraph number 53, ABL International. The decision of this court in ABL International Limited versus Export Credit such and such is significant and was the turning point in the scope of judicial review in contractual matters. In this landmark ruling, this court decisively laid down and approved that a relief against a state or its instrumentalities in matters related to contractual obligations can be sought under the writ jurisdiction. The relevant observations read. Then, paragraph number 23 and 27 from ABL judgment, my lord, is vetted. So now the door is open. Now the change, my lord, will be visible. Paragraph number 55. In Noble Resources Limited and State of Odisha, this court, for the purpose of judicial review on contractual dispute, recognized a distinction between a matter where the contract is at the threshold or at the stage of breach. My lord, we are at the stage of breach, according to their allegation. It held that at the threshold, the court's scrutiny is more intrusive and expansive, while at the stage of breach, it is discretionary, except where the action is found to be arbitrary or unreasonable. The relevant observations read under 6C. It is right that if an action on the part of state is violative on the equality clause contained in Article 14 of the Constitution of India, writ petition would be maintainable even if the contractual field. A distinction indisputably must be made between a matter which is at the threshold of a contract and a breach of a contract. Whereas the former, the court's scrutiny will be more intrusive. In the latter, the court may not ordinarily exercise its discretionary jurisdiction on a judicial review unless it is found to be violative of Article 14 of the Constitution. While exercising contractual powers also, the governmental bodies may be subject to judicial review in order to prevent arbitrariness or favoritism on this part. Indisputably, inherent limitations exist, but it not be correct to opine that under no circumstances a writ will lie only because of it involves a contractual matter. Then, my lord, the judgment I have already placed, 56. There is a change. The law on the subject with which I have already placed Joshi Technologies, my lord, Joshi Technologies being quoted, including 69.1, the court may not examine the issue unless the action has some public law character attached to it. Then, my lord, other judgments are being scrutinized. Paragraph 70.6. Ordinarily, has my lord got it?
Yes.
Ordinarily, where a breach of contract is complained of, the party complaining of such breach may sue for specific performance of the contract if the contract is capable of being specifically performed. Otherwise, the party may sue for damages. 70.8. If the contract between private party and the state instrumentality is under the realm of a private law and there is no element of public law, the normal course for the aggrieved party is to invoke the remedies provided under ordinary civil law rather than approaching the High Court under Article 226 of the Constitution of India and invoking its extraordinary jurisdiction. 70.9. The distinction between public law and private law element in the contract with the state is getting blurred. However, it has not been totally obliterated. And where the matter falls purely in private field of contract, this court has maintained the position that writ petition is not maintainable. The dichotomy between public law and private law rights and remedies would depend on the factual matrix of each case, and the distinction between public law remedies and private law field cannot be demarcated with precision. In fact, each case has to be examined on its facts whether the contractual relations between the parties bear insignia of public element. Once on the fact of a particular case, it is found that the nature of activity or controversy involves public law element, then the matter can be examined by High Court in writ petitions under Article 226 of the Constitution of India to see whether action of the state or instrumentality or agency of the state is fair, just, equitable, or that relevant factors are taken into consideration and irrelevant factors have gone into decision making. So, my lord, then, my lord, kindly, 57.4. Exercise of writ jurisdiction. My lord, this is in page number 505. Exercise of writ jurisdiction after termination of breach of contract. A relief by way of a writ under Article 226 of the Constitution will also lie against a termination or a breach of contract, whether such action is found to be either palpably unauthorized or arbitrary. Before turning away the parties to remedy of civil suit, the courts must be mindful to see whether such termination or breach was within the contractual domain or whether the state was merely purporting to exercise powers under the contract for any ulterior motive. Then 57.5, other relevant considerations for exercise of jurisdiction. MP power management case, my lord, is being quoted. Then paragraph number 59. It is needless to state that in matters concerning specific modalities of the contract, such as required work, execution method, material quality, etc., the court usually refrains from interference. State authorities, like private individuals, have a consensual element in a contract formation. The stipulations of the term in the underlying contract purpose are part of the consensual aspect. which need not be entertained by the courts in writ jurisdiction, and the parties may be delegated to ordinary private law remedy. Judicial review does not extend to fixing contract stipulations, but ensures that the public law authorities act within the authority to prevent arbitrariness. Then last two paragraphs, 60 and 61. Thus, the demarcation between private law element and public law element in the context of contractual disputes, if any, may be assessed by ascertaining whether the dispute or controversy pertains to the consensual aspect of the contract or tender in question or not. Judicial review is permissible to prevent arbitrariness or public authorities and to ensure that they do not exceed or abuse their powers in contractual transactions and require overseeing the administrative power of public authorities to award or cancel contracts, etc. Therefore, what can be culled out from the above is, although disputes arising purely out of contracts are not amenable to writ jurisdiction, yet keeping in mind the obligation of the state to act fairly and not arbitrarily or capriciously, it is now well settled that when contractual powers is being used for public purpose, it is certainly amenable to judicial review. So, my lord, this is akin to the submission I made on the earlier date, that there should be at least some public law element flavor in the dispute to approach the Honorable High Court in its high prerogative jurisdiction. And here in this case, there is no public law element, and the action of the state cannot be termed, if at all I can be termed as a state. I am discharging public function. I am not disputing that I am amenable to jurisdiction otherwise as an organization, but the action on my part cannot be termed as merely arbitrary, because I will submit on merit if required that my defense mainly is, one part of my defense is, my lord, the VRS scheme which he is claiming benefit of, it was actually floated by a body which was not competent to float such scheme. Therefore, my lord.
So right now the issue is maintainability of the
Maintainability.
writ petition. Merits we'll see later on.
My lord.
Yes, your answer on merits.
I am an employee of an, say, Article 12 authority. I discharge my duties for the whole of the month. The employer does not pay me wages. It's a contract. Every employment is a contract. So not I have to approach the civil court if this submission is to be accepted for ventilation of my grievance. That's not the law. And the judgment note which says, which has been cited at the bar, itself says what is arbitrary has an insignia of public element. I'm not in a every employment is a contract except government service. So an Article 12 authority who makes an employee work for whole of a month and does not pay wages can very well say the employee is stopped from approaching the writ court because it is a contract of employment. But the same judgment, I don't have to cite judgments for that purpose. It was the division main judgment of our court was a case of termination from service which was sought to be restored. The contract was sought to be restored through the writ petition. In that context, the court held it's a private contract which the court should not enter into. But the 2015 judgment, please have a look at page 1105 to 1107. It supports my cause. And what is VRS? VRS is an invitation to offer. The employee applies, that's an offer. The employer accepts, that's a contract. Now, not paying under the contract, that's a case of not how the government is or the state is acting. Please come to 1105. I'm sorry, 1103 first and then 1105. And paragraph 69 at 1103.
Yes.
Further legal position which emerges from various judgments of this court dealing with different situations or aspects relating to the contracts entered into by the state or public authority with private parties can be summarized as under. Not pausing here for a moment. In this case, the party wanted a particular clause in a contract to be entered or to be incorporated by the state. In a commercial contract, the party wanted that this should be a clause in the contract. At the stage of entering into a contract, the state acts purely in its executive capacity and is bound by the obligations of fairness. That's Article 14. State in its executive capacity even in the contractual field, is under obligation to act fairly and cannot practice some discriminations. So, not duty to act fairly, not Article 14 is also one of the grounds. Even in cases where question is of choice or consideration of competing claims before entering into the field of contract, facts have to be investigated and found before the question of a violation of Article 14 could arise. So, competing rights and obligations are being examined by court for the purpose of entertainability qua Article 14. If those facts are disputed and require assessment of evidence, the correctness of which can only be tested satisfactorily by taking detailed evidence involving examination and cross-examination of witnesses, the case could not be conveniently or satisfactorily decided in proceedings under Article 226. In such cases, court can direct the aggrieved party to resort to alternative remedy of civil suit. Writ jurisdiction of High Court under 226 was not intended to facilitate avoidance of obligation voluntarily incurred. Writ petition was not maintainable to avoid contractual obligation, occurrence of commercial difficulty, inconvenience or hardship in performance of the conditions agreed to in the contract can provide no justification in not complying with the terms of contract which the parties has accepted with open eyes. It cannot ever be that a licensee can work out the license if he finds it profitable to do so, and he can challenge the conditions under which he agreed to take the license if he finds it commercially inexpedient to conduct this business. So, the first sentence of clause 5 supports the cause of this writ petition. Ordinarily, where a breach of contract is complained of, the party complaining of such breach may sue for specific performance of the contract if contract is capable of being specifically performed. Otherwise, the party may sue for damages. Writ can be issued where there is executive action unsupported by law, or even in respect of a corporation there is denial of equality before law or equal protection of law, or it can be shown that action of the public authorities was without giving any hearing and violation of principles of natural justice after holding that action could not have been taken without observing principles of natural justice. If the contract between private party and the state instrumentality or agency of the state is under the realm of a private law and there is no element of public law, the normal course for the aggrieved party is to invoke the remedies provided under ordinary civil law rather than approaching the High Court under 226 and invoking its extraordinary jurisdiction. The distinction between public law and private law element in the contract with state is getting blurred. However, it has not been totally obliterated, and where the matter falls purely in private field of contract, this court has maintained the position that writ petition is not maintainable. Dichotomy between public law and private law rights and remedies would depend on the factual matrix of each case, and distinction between public law remedies and private law field cannot be demarcated with precision. In fact, each case has to be examined on its facts, whether the contractual relations between the parties bear insignia of public element. Once one of the facts of a particular case, it is found that nature of the activity or controversy involves public law element, then the matter can be examined by the High Court in writ petitions under 226 to see whether action of the state or instrumentality or agency of the state is fair, just and equitable, or that relevant factors are taken into consideration and irrelevant factors have not gone into the decision making process, or the decision is not arbitrary, or are in the alternative. Then 11. The scope of judicial review in respect of disputes falling within the domain of contractual obligations may be more limited, and in doubtful cases, the parties may be relegated to adjudication of their rights by resort to remedies provided for adjudication of purely contractual dispute. The doubtful cases would mean a disputed question of fact. Now please turn over to the next page. The second sentence of that page. The fourth line from the top of that page, the sentence begins with the words, however. However, this conduct of the appellant or even the respondents was outside the scope of the contract, and that by itself may not give any right to the appellant to claim a relief in the nature of mandamus to direct the government to incorporate such a clause in the contract in the face of the specific provisions in the contract to the contrary as noted above, particularly Article 32 thereof. It was purely a contractual matter with no element of public law involved thereunder. So, the licensee was wanting certain clauses to be incorporated in the contract vis-a-vis the benefits which he has already reaped out of the same contract. In that context, the court held there are certain disputed questions of fact, which is not a fit case for invoking writ jurisdiction, because it's a contractual, it's really a contract which is being sought to be created. But once a VRS is accepted, not on merit, I'll submit later. But for the time being, I proceed on the basis that a VRS is accepted. A VRS scheme is floated, it's an invitation to offer. I offer myself by making an application. The employer accepts it. It's a concluded contract. Now the obligations flow from this contract. Like not an employer not paying me wages. Now please see the 2024 judgment. And what I shall show the 2026, two paragraphs from the 2026 judgment also. Lordship may straightway come to paragraph 57.3. Of the 2024 citation.
2024. 54.
57.3.
57.3. Yes.
It's probably page 504.
Yes. Yes.
Exercise of writ jurisdiction after the contract comes into existence. That's the caption. This court in MP Power Management case held that even after the contract comes into existence, an action may lie by way of a writ to either. But Radhakrishna Agarwal said that writ petition is maintainable at the stage of entering into contract. Either. So it's all in the alternative. One, obviate an arbitrary or unreasonable action on the part of the state, or to call upon it to honor its obligations unless there is a serious or genuine dispute as regards the liability of the state from honoring such obligation. No, this is a complete answer. Existence of an alternative remedy or a disputed question of fact may be a ground to not entertain the parties in a writ as long as it is not being asked as smokescreen to defeat genuine claims of public law remedy. So the first sentence in no unequivocal terms laid down as a proposition of law that calling upon the state to honor its obligations unless there is a serious or genuine dispute as regards the liability of the state from honoring such obligation makes the state action amenable to writ jurisdiction even in the contractual field. (82.5) After the contract is entered into, there can be a variety of circumstances which may provide a cause of action to a party to the contract with the state to seek relief by filing a writ petition. Without intending to be exhaustive, it may include the relief of seeking payment of amounts due to the aggrieved party from the state. The state can indeed be called upon to honor its, it's in italics, to honor its obligations of making payment unless it be that there is a serious and genuine dispute raised relating to the liability of the state to make the payment. Such dispute ordinarily would include the contention that the aggrieved party has not fulfilled its obligations, and the court finds that such a contention by the state is not a mere ruse or a pretense. It's like section 53 of the Contract Act. The existence of an alternative remedy is undoubtedly a matter to be borne in mind in declining relief in a writ petition in a contractual matter. Again, the question as to whether the writ petitioner must be told of the gates would depend upon the nature of the claim and relief sought by the petitioner, the questions which would have to be decided, and most importantly, whether there are disputed questions of fact, resolution of which is necessary as an indispensable prelude to the grant of the relief sought. Undoubtedly, while there is no prohibition in the writ court even deciding disputed questions of fact, particularly when the dispute surrounds demystifying of documents only, the court may relegate the party to the remedy by way of a civil suit. Not a clarification of a document. Demystifying which may require evidence. The existence of a provision for arbitration, which is a forum intended to quicken the pace of dispute resolution, is viewed as a near bar to the entertainment of a writ petition. See in this regard the view of this court in ABL, explaining how it distinguished the decision of this court in State of UP versus Bridge and Roof by its observations in para 14. The need to deal with disputed questions of fact cannot be made a smokescreen to guillotine a genuine claim raised in a writ petition when actually the resolution of a disputed question of fact is unnecessary to grant relief to a writ applicant. The reach of Article 14 enables a writ court to deal with arbitrary state action even after a contract is entered into by the state. A wide variety of circumstances can generate causes of action for invoking Article 14. The court's approach in dealing with the same would be guided by undoubtedly the overwhelming need to obviate arbitrary state action in cases where the writ remedy provides an effective and fair means of preventing miscarriage of justice arising from palpably unreasonable action by the state. A relief by way of a writ under Article 226 will also lie against a termination or a breach of a contract wherever such action is found to either be palpably unauthorized or arbitrary. Before turning away the parties to the remedy of civil suit, the courts must be mindful to see whether such termination or breach was within the contractual domain or whether the state was merely purporting to exercise powers under the contract for any ulterior motive. Any action of the state to cancel or terminate a contract which is beyond the terms agreed thereunder will be amenable to the writ jurisdiction to ascertain if such decision is imbued with arbitrariness or influenced by any extraneous consideration. The relevant observations read under MP, that is once again quoted 82.11. Termination of contract can again rise in a wide variety of situations if, for instance, a contract is terminated by a person who is demonstrated without any need for any argument to be the person who is completely unauthorized to cancel the contract. There may not be any necessity to drive the party to the unnecessary ordeal of a prolix in such a case where there is no dispute to be and avoidable round of litigation. The intervention by the High Court in such a case where there is no dispute to be resolved would also be conducive in public interest apart from ensuring the fundamental right of the petitioner under Article 14 of the Constitution. When it comes to a challenge to the termination of a contract by the state, which is a non-statutory body, which is acting in purported exercise of the powers of rights under such a contract, it would be oversimplifying a complex issue to lay down any inflexible rule in favor of the court, turning away the petitioner to alternate fora. Ordinarily, the cases of termination of contract by the state acting within its contractual domain may not lend itself for appropriate redress by the writ court. This is undoubtedly so if the court is duty-bound to arrive at findings which involve untying knots which are presented by disputed questions of facts. Undoubtedly, in view of ABL, if resolving the dispute in a case of repudiation of a contract involves only appreciating the true scope of documentary material in the light of pleadings, the court may still grant relief to an applicant. We must enter a caveat. The courts are today reeling under the weight of a docket explosion, which is truly alarming. If a case involves a large body of documents and the court is called upon to enter upon findings of facts and involves merely the construction of the document, it may not be an unsound discretion to relegate the party to the alternative remedy. This is not to deprive the court of its constitutional power as laid down in ABL. It all depends upon the facts of each case as to whether, having regard to the scope of the dispute to be resolved, whether the court will still entertain the petition. In a case, the state is a party to the contract, and a breach of a contract is alleged against the state. A civil action in the appropriate forum is undoubtedly maintainable, but this is not the end of the matter. Having regard to the position of the state and its duty to act fairly and to eschew arbitrariness in all its actions, resort to the constitutional remedy on the cause of action that the action is arbitrary is permissible. However, it must be made clear that every case involving breach of contract by the state cannot be dressed up and disguised as a case of arbitrary state action, while the concept of an arbitrary action or inaction cannot be cribbed or confined to any immutable mantra and must be laid bare with reference to the facts of each case. It cannot be a mere allegation of breach of contract that would suffice. What must be involved in the case must be action or inaction, which must be palpably unreasonable or absolutely irrational and bereft of any principle. An action which is completely malafide can hardly be described as a fair action and may, depending on the facts, amount to arbitrary action. The question must be posed and answered by the court, and all we intend to lay down is that there is a discretion available to the court to grant relief in appropriate cases. Now please turn over to paragraph 58. What can be discerned from the above is that there has been a considerable shift in the scope of judicial review of the court when it comes to contractual disputes where one of the parties is the state or its instrumentalities. In view of the law laid down in ABL and MP power, it is difficult to accept the contention of the respondent that the writ petition filed by the appellant before High Court was not maintainable and the relief paid for was rightly declined by the High Court in exercise of its jurisdiction. Where state action is challenged on the ground of being arbitrary, unfair, or unreasonable, the state would be under an obligation to comply with the basic requirements of Article 14 and not act in an arbitrary, unfair, and unreasonable manner. This is the constitutional limit of their authority. There is a jural postulate of good faith in business relations and undertakings which is given effect to by preventing arbitrary exercise of powers by public functionaries in contractual matters with private individuals. With the rise of the social service state, more and more public-private partnerships continue to emerge. Not I skip over that. Please come to the last sentence of that page in paragraph 59. Judicial review does not extend to fixing contract stipulations, but ensures that the public authorities act within their authority to prevent arbitrariness. That's the ratio of this judgment.
Here, the authority is also raising an issue that the person who entered into that, not the person, the body which entered into that VRS scheme was not the competent authority. So there is another dispute which is sought to be raised by the authority.
Now, not an action is complete before this decision is taken.
Which decision?
The decision to say that there is no VRS scheme in existence. Now, this is pages 8 to 12 of their opposition clearly indicates that there is a dispute between the Board of Governors and the Board of Trustees. The Board of Trustees filed a writ petition in this Honorable Court challenging the action of the Board of Governors, by which the Board of Governors resolved that the Board of Trustees will be non-functional or a non-existent body. The writ petition got dismissed. In appeal, the court restored the Board of Trustees. And on restoration, the Board of Trustees said that there is no VRS in existence.
Writ petition was allowed.
I'm sorry, whatever it is. No, not writ petition was allowed. I'm sorry. The resolution was cancelled. So the writ petition was allowed. So the resolution to disallow the Board of Trustees to exist was set aside. Now the Board of Trustees on a later date decided that there is no VRS and it is withdrawn. What happens to
some amount of dispute is sought to be raised by the authority.
Not this sought to be, not that's the second question. Not is this withdrawal having a retrospective effect? That's the question of law. That's the question of law.
Why will this question of law be entertained while deciding this issue?
Because of not the paragraph 82.9 to 11 of that MP power. Please read that, please recollect the paragraph in italics. What the Honorable Supreme Court reminds the High Courts is, if it requires appreciation of evidence through a bulk of documents.
No, may not be bulk, at least some document is there.
What is the document? I say on a particular date before this employee had been, after the employee had been released, the VRS is withdrawn. In August 2024, the employee stands released. The decision to withdraw the VRS is on a later date through a resolution of the Board of Trustees.
Now it is withdrawn only because the body which adopted that decision was not the competent authority to do it.
That's neither here nor there. They say that this VRS is not taken by me, it should not be allowed to exist. What happens to the situation in the meantime? It's like a de jure situation.
Yes.
Now, first and foremost, I need not cite any judgment for this proposition that if this is an administrative act. An administrative act cannot have a retrospective effect if it adversely affects anybody's rights. As a general proposition of law, as a general principle. Now, an action is concluded in the meantime. Some sort of a de jure principle. And I am seeking performance of this obligation, which the Honorable Supreme Court once again in MP power restores. That if it is a question of discharging obligations, then the writ court will not turn its face away. Not that paragraph in italics, 82.9 to 82.11.
All right.
But I am not seeking not to create any right. It's not a question of creation of a right as in Joshi International, the 2015 judgment. The licensee wanted a term to be incorporated in a contract. That's not the case here. Even in that case, not the Honorable Supreme Court had laid down the principles where writ petition is entertainable in contractual disputes. But ABL International in that 2023 Supreme Court was recognized as a waterfall judgment in contractual matters. In alignment thereof, the Honorable Supreme Court has expanded the scope to mean that if the action of a state is arbitrary, then it comes within the public domain. Please come to the 2026 judgment now. But just 2 paragraphs from this judgment.
2026.
Manada, it's a later one. Now copy down. Okay. It is just for the proposition of law, nothing else. Please come to page 366, paragraph 45. Since then, it has been reaffirmed that judicial review in contract matters operates only where the action is palpably unreasonable or absolutely irrational and bereft of any principle. These principles are neither ornamental nor abstract. They arise from the nuanced understanding that government contracting, unlike private commerce, is an instrument of governance. The rule of law demands that executive discretion be rational and fair, but it equally demands that courts respect the autonomy necessary for effective administration. Public interest requires not judicial micromanagement, but judicial assurance that power has been exercised within lawful bounds. So that's the scope of judicial review, non-arbitrariness in the action. That is to be tested. And infighting has led to non-release of the dues which were finally decided to be given to me. And I have so inconveniently changed my position that I was released from service.
It's not that you were thrown away. It was your choice that
I
you
applied. It was accepted and released.
Yes, you sought VRS.
So that on the understanding, I got released. But had this VRS not been there, I would have earned my salaries.
Other options would have been there.
I would have earned my salaries in the establishment.
Yes.
So now I'm not the judgment not which says VRS is a contract. Please see not the context in which that judgment was delivered. 2006. 2006, 3 SCC 708.
দেখুন ওখানে আছে।
Paragraph 2.
Yes.
The members of the union were employees of Heavy Engineering Corporation Limited, the respondent. It is a Sikh company. It was referred to BIFR in terms of the provisions of SICA. As one of the measures for revival of the company, it floated a scheme for voluntary retirement of its employees. One of such schemes was floated in 1987, which remained in force up to 1990. On and about 20th of October 1990, a revised voluntary retirement scheme was floated. The said scheme was to remain effective for an initial period of 1 year, but admittedly the same has been extended from time to time. Both unionized and non-unionized employees numbering in thousands opted thereunder. Pursuant to or in furtherance of the said scheme, the following benefits were to be given to the employees opting for voluntary retirement. The company, paragraph 3, the company issued a circular letter number 9th October 1997, effecting revision in the scale of pay. The same, although issued on 9th October 1997, was given retrospective effect from 1/1/1992. It was to remain in force for a period of 5 years from the said date, that is up to 31st of December 96. Clause 3.2 reads as under. The appellants here in paragraph 4 indisputably opted for the said voluntary retirement scheme dated 22nd of October 1990 and retired between the period 1/1/92 and 31st of December 1996. In view of the revision of scales of pay by the company in terms of the aforementioned circular of 1997, a contention was raised by the appellant that they were entitled to the benefit thereof. The matter was referred to the Government of India and the Ministry of Industries by a letter of 1993, which stated that the employees who had opted for voluntary retirement in terms of the aforementioned scheme were entitled to the benefit of the revision of pay in the following terms. Similar, the retrospective pay revision was sought to be extended to employees who had already separated voluntarily. As despite the said purported direction of the central government, the benefit of the revised scale of pay was not extended to the appellants herein. They filed a writ petition before the Ranchi High Court in the High Court of Judicature at Patna. A learned single judge of the said court dismissed the said writ petition, opining that the appellants had no legal right in relation thereto. It was furthermore opined that when the said circular was issued, the appellants having voluntarily retired, it was not applicable in their case. The latest patent appeals preferred there against by the appellants were also dismissed. The division bench of High Court in its judgment, which is impugned herein, relying upon the basis of Hindustan Machines, held that as the respondents had voluntarily retired under a special scheme, they were not entitled for revised scale of pay as revised under the circular of 1990 dated 1/3/1991. In assailing the said judgments, the learned counsel appearing on behalf of the appellants would submit that the High Court committed a manifest error in arriving at the said conclusion insofar as it proceeded on the basis that the VRS dated 22nd October 1990 was a special scheme, as the said remained in force for a period of 10 years. Paragraph 9. Learned senior counsel appearing on behalf of the respondent on the other hand would contend that having regard to the contract of voluntary retirement, the employees concerned, having already taken the benefits admissible under the scheme, including the proportionate pay for their future service, were not entitled to benefits of revised scale of pay. The employer, in arranging its financial plan on request to payment of benefits under the voluntary retirement scheme, could not and did not anticipate that there would be a revision in the pay scale, and the same would also be applicable to the employees who had opted for voluntary retirement. Pensioners, according to the learned counsel, stand absolutely on a different footing, inasmuch as even after their superannuation, they continue to draw pension. Similarly, the family members of the deceased employees would be entitled to family pension. Upon such voluntary retirement in terms of the scheme, the jural relationship comes to an end, Mr. Kumar argued. Drawing our attention to the distinction between clauses so and so, it was submitted that it specifically lays down as to what was to be included has been included and what was to be excluded has been excluded. Thus, the company never had any intention to include the cases of the employees who had opted for voluntary retirement in terms of the scheme. They have not been included in clause 3.2 of the circular. That revised pay scale being applicable to a person who is in service, a fortiori the same would be inapplicable to the persons who are not in service according to the learned counsel. So, we are pausing here for a moment. The scheme of the writ petition was to alter the provisions of the VR scheme and read a revised pay scale into that VR scheme which it did not contain. In reply, learned counsel submitted that the jural relationship was created in terms of the scheme itself, and in this behalf, our employees in the equivalent salary grades who ceased to be in the employment of the corporation due to superannuation or death shall be eligible for arrears on pro rata basis. An offer for voluntary retirement in terms of a scheme, when accepted, leads to a concluded contract between the employer and the employee. In terms of such a scheme, an employee has an option either to accept or not to opt therefore. The scheme is purely voluntary in terms whereof the tenure of service is curtailed, which is permissible in law. Such a scheme is ordinarily floated with the purpose of downsizing the employees. It is beneficial both to the employees as well as to the employer. Such a scheme is issued for effective functioning of the industrial undertakings. Although the companies state within the meaning of Article 12, the terms and conditions of service would be governed by the contract of employment. Thus, unless the terms and conditions of such a contract are governed by a statute or statutory rules, the provisions of the Contract Act would be applicable both at the formulation of the contract as also the determination thereof. By reason of such a scheme only is an invitation to offer floated, when pursuant to or in furtherance of such a voluntary retirement scheme, an employee opts therefore, he makes an offer which upon acceptance by the employer gives rise to a contract. Thus, as the matter relating to a voluntary retirement is not governed by any statute, the provisions of the Contract Act therefore would be applicable too. But I also say that I'm not trying to alter the terms of contract. It's a concluded contract. It's a concluded action between the parties. You only fulfill your obligations, not which MP power remains in respect of an Article 12 authority. It is also common knowledge that a scheme of voluntary retirement is preceded by financial planning. Finances for such purpose, either in full or in part, might have been provided for by the central government. Thus, financial implications arising out of implementation of a scheme must have been borne in mind by the company, particularly when it is a sick industrial undertaking. Offers of such number of employees for voluntary retirement in that view of the matter were to be accepted by the company only to the extent of finances available therefore. So the court said you can't alter the contract now. You opted with your eyes wide open that on the date of your enrollment in the company, whatever was your salary, that would form the basis of calculation of VR dues. Now, after a subsequent revision of pay of wages or pay of salary, which had a retrospective effect during your tenure of employment, you cannot alter the terms of the VR contract.
This will be your submission, or would you like to make
This is my submission on maintainability.
maintainability? He
That's
would reply. I'll hear on the next day.
Grateful, my lord.
Heard submissions made on behalf of the respondents and the writ petitioner on the issue of maintainability. Stop. The respondents would give the reply on the next date. A date has to be fixed. কি ডায়েরিটা দেখে বলতে পারবেন?
Engages an employee. It's a contract of employment. I work for 6 months, 4 months wages are paid. The employer shows me the door of civil court to get
No.
my wages.
What will happen if the same thing happens in respect of the CAC employees?
That's a private body.
Yes. So
That's a private body.
this how much will come?
So far as maintainability of the writ is concerned, that is completely out of the question because the Board of Trustees itself filed a writ petition against the Board of Governors.
This has to be seen. But
Grateful, my lord. It is always a privilege to have.
But I would
matter
obviously
with
not come to the writ court
my
if a
lord.
private company does not pay my wages. Grateful to your lordship. That's right, item number 1.
non-prosecution.
I do not know.
But this is my contempt application. Lordship's parent order has not been complied with by the contemptor Pradhan. That's why Lordship, my lord, imposed cost 30,000, directed to deposit before the, my lord, DFO. My lord, I made the application under section 6 of the Right to Information Act, whether they have planted or not. They have completed. This is the report. But, my lord, one thing, that is, my lord, Lordship's parent order has not been complied with by the contemptor. Though, my lord, he has submitted the affidavit of compliance that I have done everything. My lord, let him place the records before our lordship that he has referred the matter before the, my lord, SDO. My lord, I requested the SDO.
Not pressed.
My lord, I requested the SDO. SDO, my lord, twice. My lord, informed the Pradhan to place the records. My lord, he did not. Otherwise, my lord, I will be the remediless. So, my lord, let him.
It out or not pressed.
My lord, this is the regarding plantation. My lord, I have no comments. He has completed.
Yes,
Yes, my lord, utilize the. But my lord, actually, parent order has not been complied with. My lord, total, my lord, misleading to your lordship's court. My lord, affidavit of compliance that on that day I have adopted the resolution, passed the order, placed before the SDO. Nothing has been done. My lord, that's why, my lord, my request, my lord, let him. I will communicate your lordship's order. My lord, fix the matter in any date. Let him produce the records before the lordship. Pradhan is the contemptor. Otherwise, my lord, I will be the remediless man.
The order has not been complied.
No, my lord. Nothing. Mislead to your lordship's court, my lord.
What?
By way of affidavit.
Yes.
Affidavit of compliance. Lordship, nothing. Here,
affidavit of
my lord, hearing was not conducted. Nothing was done. Hearing was not conducted, not placed before the SDO. No order has been passed. Nothing. In spite of that, my lord, affidavit of compliance can be seen. One day more, my lord.
Right, please come. Learned advocate for the petitioner submits that the order passed by the court has not been complied with by the Pradhan till date. Stop. Let notice be served upon the learned advocate representing the Pradhan. Are you aware?
Yes, my lord.
Release the matter for further consideration on 3rd September.
Another same heading, my lord.
To be mentioned. Impossible.
Safankar, my lord.
Application.
Yes. Yes.
Heading lega dorkar nei. It will appear in the regular course.
Intimate to the advocate, my lord. Intimate.
Item number 3, I am the petitioner lordship. In point number 3, lordship petitioner retired from the service. It will be 2024, and it is wrongly written 2020.
This will be 2024.
Lordship.
Second line, paragraph 3. Yes.
My lord, in this transfer matter, the spelling of the petitioner is wrongly recorded. It would be Badari instead of Badri.
Name of the petitioner.
Grateful, my lord.
I have for the petitioner, after passing the order by your lordship, board complying all and issued registration certificate of registration to the students of the college, my lord. So the board issued registration certificate to all the students.
It has issued registration
lordship.
certificates. Right.
Of the
Thank you,
copy.
Lordship, I am for the board led by Mr. Ratul Biswas.
Yes.
Give
Some
your
of the
appearance.
copies, yes.
Give your appearance. Learned advocate for the petitioner submits that.
Some of the copies I have handed over, my lord. All the students have got the registers.
Board of Primary Education has already issued registration certificate in favor of the petitioners.
In favor of the students of the college.
At the students of the college.
Students, your lordship.
Stop. The grievance of the petitioners have been
Amen.
redressed, has been redressed. Stop. Next. In view of the above, there is no requirement of proceeding with the writ petition any further. Stop. The writ petition stands disposed of. Take this back.
Lords,
This is not required. এগুলো ফেরত
Lordship, I appear for NCT,
record
Lordship.
appearance of
আমার
NCT.
Appear.
I will statement. আমার দিন
Grateful, Lordship.
গ্রেটফুল লর্ডশিপ। ঠিক আছে, আমি দিয়ে দিচ্ছি।
My lord, I am appearing on behalf of the petitioner or applicant. Your lordship, is a contempt application non-comply of your lordship's order dated 23rd of February, wherein your lordship directed to grant 2 marks as prior teaching experience to the petitioner therein for the service, for counting or consider the service of the said petitioner. My lord, kindly, I have served the contemners the service to the. Now kindly come to page 15 of your lordship's order. And the paragraph is, my lord, paragraph 16.
Any appeal preferred?
No, my lord, no appeal preferred from the side of the WBSSC. Petitioners belong from EWS category.
Whatever. EWS was not the issue over here. It was 2 marks.
It was the 2 marks as prescribed in the rules, 2025 rules,
Yes.
wherein if you the prior teaching experience, 2 marks should be for each year. And my service should be counted from 27th April 2018 to 30th June 2019. 1 year, 2 months, I'm entitled to get 2 marks. Initially, they grant 2 marks, but subsequently they deleted the 2
I
marks.
have followed it. But then serve.
I have already served, your lordship.
Who did you serve?
The chairman of the WBSSC.
This is a contempt, you say. How could you serve prior to the matter being taken?
As per lordship's direction, I mentioned before the
Yes.
application on Monday, and
Yes.
lordship directed to serve the copy of the contempt application during the time of hearing.
লিখুন তো। You in that case find out Dr. Patro.
Then, my lord, kindly give us short pass over.
All right. রাখুন, let it be passed over.
Oblige. I appear for the IIT. Lord, this is the hearing matter. Lord.
You appear for the
IIT. Lord.
IIT.
Lordship, I am for the petitioner. This matter is fixed for final arguments. It was last fixed on 27 September. And then the matter could not be taken up as the concerned department did not send the reports. Lordship, today suddenly it came up. Lordship, the senior leading me is out of station, praying for a week's accommodation, Lordship.
How can it?
So, lordship, evidence what directions for evidence was there, lordship. We have filed the evidence in opposition, lordship. They have already, lordship, prayed for extension.
Lordship,
Devashish Mitra is your name?
no, my seniors.
Your senior's name?
Yes, your Lordship.
The matter was mentioned.
In 13/7, it came out.
Yes.
I'm mentioning it was fixed on 27/7. On that day, the matter was not taken up for hearing. Lordship, senior is outside the station. Only 1 week
slip রয়েছে। Urgency that was pleaded, are you aware?
No, my lord. No, my lord.
Then you mention matters and at the time of call you do not know what the matter is. It is recorded that there is an urgency. What is the urgency?
Lordship, I'm not aware of it.
Are you aware whether any urgencies?
There's no urgencies there, Lordship. In the year of 2023, Lordship, this present petitioner, Lordship, want to, Lordship, intend to, Lordship, admit in the MTech examination. But in the admission test, Lordship, there is a minimum 6 GDP is required, Lordship. He is required only, Lordship, 5.4. Thereafter, Lordship, his provisional admission was terminated. Against that, Lordship, he has preferred this writ petition. And in that writ petition,
Provisional admission was
was terminated because he has not the requisite qualification. In the Lordship admission, posterior Lordship, 6.6, minimum 6 is the GDPA required. But he has only acquired less than 6.
Lordship, this provisional admission was cancelled after completing of 4 semesters of MTech.
what is the position of the student now?
Lordship,
You know nothing of the matter?
Lordship, I'm not prepared with the matter. Lordship, senior is supposed to argue
You
the
should
matter.
have taken instruction.
Lordship, it came up suddenly, and that is why we are not.
Not suddenly, it was mentioned, and that is
Your
the
Lordship.
reason it was mentioned for upgradation.
Yes, Lordship, it was fixed on 27th. I apologize for it.
Then?
Lordship. Kindly give us a week's accommodation.
The matter was mentioned citing urgency. Stop at the time of call. Learned advocate for the petitioner is not prepared. Submits that he is not prepared. Stop. Next, in view of such submission, release the matter for further consideration on 7th of September.
Great for you, Lordship.
Not under urgent motion.
Item number 8, I beg to appear on behalf of the writ petitioner.
I am for the state, my lord. And no intimation was given for the upgradation of the matter.
But that is true, my lord. I only mentioned this matter. That this matter will appear as an upgraded motion today was not intimated. My lord, I will tend that, my lord.
What is the use if you mention in
My lord,
this way?
But-
And if the matter is put up in the list as per the request of the learned advocate, then you say you have not given notice.
My lord,
It makes no sense.
no, my lord, it is my fault because, my lord,
If
it
it's
was.
your fault, then
No,
you
my
suffer
lord,
the
I
consequences.
mentioned it yesterday, my lord. That's why I
Uh,
communicate. For my personally, I will just intimate them, my lord.
Mistake, the matter was upgraded citing urgency. Stop at the time of consideration. It appears that notice of upgradation has not been served upon the respondents. Stop. Next. In view of the above, hearing of the matter cannot be conducted today. Stop. Released on 7th of September.
My lord, I will serve all the, my lord. Yesterday I couldn't serve, my lord.
Next.
My lord, I appear for the university.
Yes.
This is on the question of the review
Of.
of a medical student of his marks. Again, the same point which I had argued on the last occasion. That
West Bengal University of Health Sciences
My lord, I am
will be there.
Yes. Whether, my lord, on my prayer for review, my marks can be reduced.
Reduced or not.
That's the basic question.
Where is the bar?
Review I am seeking, not they are seeking.
Maybe.
If I seek review, my intention is that I am entitled with higher marks.
No, where is the bar that it cannot come down? If they see that it was your choice, you took the risk to apply. And now if they find that no, you have been given more marks and
That is their fault, not mine. They cannot
show me that there is a bar.
No, I would like, well, this point was never argued. I would like to argue if somebody will not seeks a review, he doesn't seek for reduction of marks.
May not seek, but where is the bar upon the reviewing authority to decrease marks if on review it is found that more marks were given to the candidate?
Then that is the problem of the examiners, not mine. The examiners, they cannot take this plea that my examiner has given you.
Show me the bar.
There may not be any bar, my lord, because they would say review means review. I would argue that this has to be argued. Suppose, I do not prefer an appeal from an order. Now,
It remains
It
as it
remains.
is.
It remains. But not if somebody else has not preferred appeal on a particular point, other point not, can the court say, no, I also review that? That is the point. But that, if your lordship not kindly allows us to argue in detail, I know this is a hard task, but I would try to persuade the court that it cannot be done. Then you are really practically threatening the people that you cannot ask for review. It might go down.
Yes.
Is it permissible?
The candidate should remain cautious.
That
Otherwise, if each and every candidate comes up with review, then what happens? The entire examination process goes over again.
But each and every time, this is a hypothetical situation. Each and every student never comes from review. Someone who feels that I am aggrieved, he comes. Now, if he comes, you are really, this is a threat. They never come for review. It might go down. Whether that would be transparent and rational. Otherwise, in the name of review, they have reduced 30 marks to show me that I am unqualified. And if that is so, then what is the examiner who had examined me paper, what is his stand? Whether he could be at all be made examiner, these things would come.
Yes, it will.
Yes, let us then, the authority must say that we have also.
And if the marks are increased, then it will come as to the person who examined, how could he give such low marks?
That's why, my lord.
So be.
That's why.
It can cut both ways.
I would submit, my lord, the student here, my lord, is in a weaker position.
Yes.
Being in a weaker position, he seeks that his marks should be reviewed to go up. He or she doesn't apply that. I am applying for review, it should go down. Therefore, my lord, the rule makers, my lord, probably did not think that on review marks should go down. Otherwise, they would have said that if you apply for review, marks will go down. That's
Show me the law of review.
Lord,
Is there any provision under which you are seeking review?
Lord, kindly come to me, Lord, the minutes of the examination of review committee.
Yes.
The review process for page 2. For university conducted UG examination.
Are you aware of what is being read?
My lord, I have that document, my lord.
Yes.
Therefore, my lord, I am just taking a lordship to the relevant portions. Last line of the first paragraph. Therefore, the committee recommended to follow some modifications as below. All the answer scripts shall be subjected for 2 valuations. The average of the total marks awarded by 2 valuators for the paper, which is rounded off to the nearest value, shall be considered for computation results. All the answer scripts where the difference between 2 valuations is 15% and more of the highest marks received by the candidate amongst 2 valuations shall be subjected to 3rd valuation if candidate was found to fail. The average of the best of 2 total marks awarded by the 3 evaluators for the paper rounded off the nearest value shall be considered. That I am here, though that the higher point which I was less my case lot will come later here. From this itself, it shows that you cannot really reduce the marks. Then it should go to 3rd evaluator. And if it is found, then it should be an average. Now that here the bottom line was 15%. In my case, it was more than 15%. And what is the 3rd evaluator done? Where is the average? These would call for, the product records to show before the lordship. And because of this, this unfortunate candidate ultimately may go out of the course itself.
Where is the main? This is, I see, these are the modifications.
Yes.
Where is the main SOP?
The main SOP my license can produce.
My lord,
Answer script may be re-evaluated by reviewers.
My lord, here, my lord, unfortunately, these 4 attempts have been exhausted in this case, my lord. Here,
4 attempts mean?
4 attempts, my lord, for my lord, a paper. Beyond 4 attempts, my lord, no one is permitted. If they fail on all 4 attempts, my lord, they are not allowed. My lord, they are seeking, my lord, a review of the third attempt of paper 2, my lord. So,
See, if we start from the beginning, let me just understand. This is to
My-
mention here that the answer script may be re-evaluated by 2 reviewers. So you appeared in an examination. You were not satisfied with the marks, you applied for review. Did you apply for re-evaluation?
We
No.
applied for review.
You applied for review. So it may be re-evaluated by 2 reviewers simultaneously, and average of marks awarded by the 2 reviewers may be taken as the marks on review as per previous SOP. So this was the previous one.
Previous SOP, I don't have that.
my lord, it's
In continuation, the exam review committee thinks it's cumbersome and complicated. Therefore, these are the modifications. All the answer scripts shall be subjected for 2 valuations. The average shall be subjected for 2 valuations. At which stage? At the very first stage, 2 valuations.
my lord, here there is another problem.
Average of the total marks awarded by 2 valuators for the papers, which is rounded off to the nearest value, shall be considered for computation of the results, where there are 2 valuations.
My lord, there is another problem. My lord, here she is already exhausted 4 attempts, seeking a review of the third attempt. So they, after the fourth time they've taken the same exam. Now they are seeking, my lord, a review of the third time. So, my lord, whether that is also permissible, my lord.
Show me the law on this. I do not know. Show me the law on this. Where is the law? You must be having your laws.
My lord,
Let him produce the original SOP, then we can satisfy lordship.
we will, my lord.
On 4 times, after 4 times, it cannot be done. What
But 4
is there?
times, my lord, it is as per the
Lordship,
regulation.
lordship,
Yes, at that time.
If a candidate is not able to qualify, he will get 4 chances. Thereafter, that's in first year. Thereafter, if he is not qualified, he will out of course. Now, my lord, this was the 4th time. Unfortunately, my lord, when she found that her marks were not up to the level, she applied for review. And then suddenly the marks were reduced to show that, wow.
Just tell me, you say she appeared for the 4th time also. That means 3rd time she was unsuccessful, and that is the reason she. So the moment you go to the 4th occasion, you don't challenge the 3rd.
No.
At that point of
It's
time, you
not
don't.
necessary. Because if I qualify in the 4th time, then I continue with the course. When I find that if I do not qualify, these are 4 chances. It doesn't mean this is a continuation. Now, when I find 4th time, I apply for review, I would have through, because reduction of marks, I'm out.
On the 4th occasion. On the 4th
4th occasion. First, second, third, I accepted. I accepted.
No, but then he says that you are reviewing the 3rd one.
Third one, sorry, third one.
Yes.
What
What about the 4th one? It's
My lord, she performed relatively better in the third. That is why she is seeking, my lord.
so 4th must be worse. Otherwise,
Yes,
why
that
will
is, my
she
lord.
come back to the
Relatively better in the third. That is why she is seeking review of third.
My lord, we have received the mark
Essentially
sheet for,
taking a chance, my lord.
my lord, we have received the mark sheet of third after the 4th exam. Therefore, when I received the mark sheet of third, I applied for review. There is no clash or will overlap.
My lord, review.
Now, if third review result is in my
If the
favor,
candidate successively is
fails.
performing not well on 4 repeated occasions, then
No, but that doesn't mean, my lord, if I will not fail first year, in first chance,
4 times you get a chance.
yes, I get a 4th turn, but when third result comes, I find that my marks would have been better. And if it is done, I will be through. In the meantime, my lord, the 4th examination was held. I had to appear. I had no choice. Now, if the review of the third result, my lord, comes in my favor, I am through. I can continue in the course. But if that is not, I am out of syllabus. The entire career is closed for me in this curriculum.
Some other career will open if,
That's a
if everybody doesn't qualify in the NEET.
That's different. But Lord, if my lord, he has the, my lord, good intention to, my lord, continue with this course.
Something else, and performance is something
A
else.
performance in one particular subject, not.
I do not know. One,
No,
two, four,
I would, my
whatever.
lord, appeal to your lordship, lord.
Show me the law.
That's the, my lord, I have placed before lordship. Let them produce what he has done. Because their own SOP, which they wanted to amend, is very clear on this point. Because that's why the
Show me the mark sheets. You
mark
have
sheet is, yes,
annexed.
that's mark sheet I give your lordship. Kindly come to the reduction, yes.
Is the candidate a beneficiary of reservation?
No, no,
The candidate is not a beneficiary of reservation.
no, no, I'm not one.
Please check.
One category.
মনে হয় মনে হয় রিজার্ভ
দাদা কোন ক্যাটাগরি এসসি এসটি হ্যাঁ না মন্ডল হলেই হবে নট নেসেসারি এসসি এসটি ওবিসি কিনা সব দেখো সেভাবে অ্যাপ্লাই
Check up the surname.
মন্ডল doesn't whether she had applied under the reservation quota.
Yes.
No, unless she had applied reservation quota, that benefit would not inure to him.
Maybe upgraded also. You never know. Maybe upgraded also.
Upgraded, it cannot be SC.
হবে হবে
হ্যাঁ এসসি ক্যাটাগরি অ্যাপ্লাই করেছিল কি
হবে হবে
অ্যাপ্লাই না করলে তো হবে না এখানে
আমি দুটো রিভিউ করলাম 53টা এবার চলে গেল স্যার পেজ 31 29 আর 31 এই দুটো ডিফারেন্স
My lord, kindly just have a look, my lord. Page 29 is my mark sheet of which I will not applied for review, where my lord, she was lacking in biochemistry by 5 marks.
5 marks makes a lot of difference.
Yes, lot of difference. I am not really challenging that. I am
Yes.
showing, and my lord, in the paper too, she had 53.
Page
kind-
29?
Yes.
Page 29?
Page 29.
Yes.
And you see in the biochemistry paper 1, she had secured 22, which is less 5 marks than the pass
Total
marks.
marks is 100. The candidate gets 22.
টোটাল
What is the pass mark?
Total is with that pass marks 80, she secured 75. Kindly come to third column. 22 plus 53, 75, which is not less 5 marks than the pass marks. Pass marks is 80.
this is the first attempt.
This is the first.
I mean second attempt. Third.
And then kindly come to the review at page 31.
না না পেজ 30 আছে তারপরে
Page 34.
হ্যাঁ
আমরা
পেজ
review করছি,
4th
sir.
attempt ওটা
34
And page 31 is the review result.
Practical including Viva. Pass marks is 40. Total is 145.
Very interesting with that.
Marks is 150. Theory, such and such.
My lord, at page 31.
Page 31.
Yes, this is the review result. Now you'll find in the biochemistry, her marks is enhanced by 5. It was 22, now it becomes 27 in paper 1. But in paper 2, where she had secured 53, it has gone down to 20.
Paper 2, 53. It has gone down to 20.
এটাই আমার চ্যালেঞ্জ
Lord, this is the area, Lord, where Lord, we have been trying to advance the argument. And if Lord, there was no variation, then she is through.
What does your law say? Please show me the provision of law.
as far as my lord the review is concerned my lord
Yes.
যেটা আপনি প্লেস করলেন ওটাই আমাকে দিয়েছে
Amended. Originalটা না দেখলে amendmentটা কেন বোঝা যাবে না?
Can you reduce marks? And the difference is quite a lot. From 53, it goes down to 20. What was the examiner doing on the first place when the candidate was awarded 52 marks?
there is my lord that my lord we will have to
Take instruction and come back, come prepared. When?
my lord
তুমি আমাকে না SOP টা দিয়ে দিও একটা কপি।
SOP আছে তো আপনার কাছে
সেটা amended টা, originalটা।
You take proper instruction as to how the difference could be so much.
In in paper 2, my lord, of biochemistry.
This is what is under challenge. From 53, it has come down to 20.
I saw that, my lord. But overall, my lord, what not fit to continue, my lord, in the MBBS course, my lord. That is
Also, now suppose
my lord.
in scrutiny, this marks is not reduced. Then the candidate is true.
No, third attempt she had failed.
That is the scrutiny. That is the scrutiny.
Yes, she failed. In the review, it came down. Initially, it was below the pass mark.
That is the reason she applied for scrutiny.
Yes. So, neither in the initial marks nor after the scrutiny, she could go through.
The scrutiny is under challenge. If she qualifies in the scrutiny, she will pass.
And, my lord, it may be re-referred, my lord, once again, my lord, for scrutiny.
No, where is the provision for re-reference? That also you will show.
That my lord, my lord, if it falls, my lord, from my lord, that very well, my lord, this could not have gone down. It in the interest of the student. It
No,
should be,
no.
That, my lord, I will.
An MBBS student.
That is where, my
You
lord.
will not want an incompetent.
That is what my
treat you.
instructions are, my
So
lord. That is what.
Show me what is your SOP and how the review is being conducted. Whether there are two evaluations, not evaluation, two valuations, and the average of the total marks of the two valuators is to be considered to be the computation of the results.
My lord.
So are there two valuations?
Whether that should have, my lord.
First.
My lord.
Second, whether the difference could be so much.
From 75, it comes down to 40.
From 53, it comes down
No,
to
man, total that. I'm not total that.
Don't go to the total.
Very well, my lord.
Only the particular
53.
subject, 53 to 20.
My lord.
23 marks. 33 marks.
33 marks.
33 marks coming down.
My lord.
Can that be done? Please come.
Thank you.
The petitioner appeared in the MBBS first professional examination. First time you appeared when?
My lord, first, second.
Got page 26, not in 2024. MBBS first professional examination, 2024 examinations.
24, 25, 26, 3 times. Where you said 4?
4. My lord, first is in August 2024.
Yeah,
Second,
2024.
yes.
Second November.
Second is November, December 2024.
November 2020, November-December 2024. Then 25 and then 26.
My lord, 25, my lord, yes. 20, my lord, third is October, November 25. Third is October, November 25. And fourth is February, March 26.
March 2026. On all 4 occasions, she was unable to obtain pass marks. Stop.
In particular subject.
In one subject. Stop. Next. The prior to appearing in the examination for the 4th time, her results for the 3rd examination was not published. Was the result not published?
Result, yes. My lord, a review result of the 3rd attempt was published on 12th February 2026.
Review?
Yes, review was published on 12th February 2026.
Yes. So how did you say that after appearing?
Yes. Fourth
examination was in February, across February, March 2026.
Therefore, before the fourth exam only I got.
Date ta nahi jani na kabe exam.
published. Review examination was not published prior to her appearing in the prior to her appearing in the examination for the fourth time. Stuff. Paragraph. The after the review marks for the third attempt was published, comma, the petitioner noticed that 33 marks were reduced in her paper 2 examination in the subject biochemistry.
Yes.
Stop. She is aggrieved by the same and has filed the instant writ petition. Stop. Submission is that the submission is that in a review, comma, the examiner could not have reduced the marks of the candidate. Stop. Paragraph. Prayer has been made. Candidate. Stop the likhun. It has been submitted. Had the candidate not applied for review, comma, then her marks would have been more than what has been awarded after review. Stop. Prayer has been made to reassess / re-evaluate the answer script of paper 2 in subject biochemistry. Stop. Paragraph. Learned advocate representing the respondent submits that the petitioner has failed in all the 4 attempts that she was entitled to appear in the examination. Stop. Paragraph the likhun je the respondents is directed to now learned advocate representing the respondents is directed to produce the rules relating to review of the answer script of an exam. Stop. The provision for decreasing marks at the stage of review or the bar thereof shall be placed before this court on the next date. Stop. Released when? Next fortnight. And the candidate won't lose anything.
That already she whatever
She's
July
last.
third attempt answer was received on 8th July, the result. So in any case,
Very well, 26th of August.
26th. I'm grateful. This could also be the other quota, it's KPC.
Yes.
It's KPC Medical College. It could also be
other
quota. It could also be
26 ছুটি ছুটি আছে ছুটি
দেখো
26 ছুটি ছুটি আছে 26 ছুটি আছে
No, but I'm told 26 is a holiday for the court.
Holiday for the court. My calendar doesn't show. না পরে হয়তো ডিক্লেয়ার হতে পারে।
It is on 25th.
All right, 25th.
25 তারিখ
25
আগে দিয়ে দিও এটা
আপনার কাছে সব আছে
না দেখে
Did you get?
But item number 6, I called Mr. Patro,
Where is
but
he?
he is not in court today. He requested to fix the matter on tomorrow, my lord.
All right, not today.
Possible.
Not today.
It will appear on tomorrow, lordship.
Yes. সেটা এইগুলোকে আগে নিয়ে এলেন কেন? আর্জান মোশন আগে আনলেন কেন?
On this matter, I am appealing for the Haldia municipality. On the last occasion, your lordship was pleased to direct
But I
me.
am appearing for the contemner, my lord. I have
to
submitted.
comply.
Contemner, he is also contemner. You
My
are
lord,
also
In
contemner.
earlier occasion,
Earlier,
Mr. Hassan was appearing both the contender, my lord. Now,
my lord, today I am appealing for the existing executive officer. Today I am appealing for the existing executive officer. Your lordship was pleased to direct to comply the said order. Already I have complied this order and order of the compliance, your lordship.
I am praying for lordship
as
leave
per
to
your lordship's direction, my lord, the
file the
investigation my lordship
compliance.
has directed me to conduct. But this is the report of the investigation. A copy may be shoved to.
How many contemners are there? I can see only one.
During the continuation of this contempt application, earlier one was retired. Subsequently, new
So
incumbent.
you didn't add the new one? You added?
No. And on the last occasion, the new incumbent appeared. As such, your lordship, my lord, kindly come to the last order, my lord. Paragraph 10. Kindly see order dated 18th of June 2026. 10, my lord, is 3. Relevant is para 4, last para.
No fine collected or charged for regularizing illegal construction was found during the course of inspection. How could it be done without?
Well, this is an online portal. All fees has been paid through online portal.
Yes, but then for regularization?
Regularization, my lord, for unauthorized construction, my lord, no money has been taken during this period, 2020 to 2026. That is the report says.
All free of cost?
No, my lord, it has not been done. It has not been done by the, my lord, the.
But then there is a charge which is levied when the illegal constructions are required to be regularized.
No, but kindly see, other than para 4, in some cases, out of 86 of 824, it is noticed that applicant has already started construction actively without getting proper building plan.
They are all illegal.
Not illegal. What they have done, they have given the building plan. It was not been sanctioned, but they have started the construction.
That is illegal.
In those cases, it has been regularized. These 86 cases out of 824. And so far as the lordship's query is after the construction, whether it has been regularized or not. In those cases, it has not been found.
It has not been found.
It has not been found.
Yes, but it should have been.
It is not there, my lord.
Law requires.
But my lord, it has all the the receipt and all has been annexed.
How could it have been done? How are illegal constructions being regularized? This is the query of the court, and this was exactly the purpose of the investigation.
But investigation so far as conducted, but no illegal construction has been found, which is subsequently regularized by the municipality.
Anyway, yes.
My lord, that in the instant case, my lord, after the following order of the court has passed on last location, my lord, 18/6 to 2026. My lord, kindly come to paragraph 9 of the order. 9, 10, and 11 of the order.
You see paragraph 4 of the order that has been recorded. What is the submission and what is your investigation report?
Mr. Ali submits there are several illegal buildings under the Korea municipality, and such constructions are regularized upon acceptance of fine. But this, it is their submission. But so far the inquiry is concerned and investigation is concerned, no such deviation has been found.
That means money has gone somewhere else.
No, money has, that may be, my lord, but it is not.
That is. What may be, that is.
That
That is. That
if
was.
somebody takes on his official command capacity without giving the money to the municipality. Somebody has taken the money, my lord. That we cannot, my lord, this is a police investigation.
That was exactly the purpose of the investigation, to find out
But that, my lord,
how.
subject to your lordship's confirmation, DM cannot do so. But there has to be a specific case, and then only the investigation can be started, whether anything has been done or not.
Yes.
But DM can go only what has been recorded. How many seeds has been deposited during this period? That we have already annexed in our report and submitted the report.
All right. Yes.
In the instant case, my lord, and after this solemn order of this honorable court, my lord, they found that the entire construction is illegal without any permission. And subsequently they have issued a notice, but the report, the affidavit affirmed by the honorable my lord, paragraph 4, my lord, it is humbly submitted that the said order dated 18/6/2026 of the honorable the honorable court Calcutta have been complied. It is detected the unauthorized construction is there without having any sanction plan. But next steps.
We are all.
By the authority concerned.
I've already sent a notice, my lord, for demolition. After that, under section 218 of the West Bengal Municipal Act, we have already sent the notice and giving on 1st August and giving time only 1 month. If he demolished, then I shall demolish. Your lordship kindly sees.
No, I have followed. Yes. What is your submission?
But I have submitted my all bank accounts. There is a direction to submit all bank accounts to the district magistrate. Accordingly, I have done. And I have prepared
Affidavit of
yeah,
compliance.
affidavit of compliance,
All right.
including all bank accounts and my income tax file.
Yes.
The original order was passed from my long back in 29 September 2023, my lord. Initially, they have the earlier contemptor stated that that construction may be regularized by making fine. Therefore, my lord, they must take steps as per subsection 5 of the section 218, my lord.
Yes, they are taking steps.
My lord.
Just issuing a notice.
Notice has to be issued. Without the notice, notice is the first step. Then the next step comes, isn't it?
Well.
Please come.
But paragraph 14 of the earlier order, my lord, all the bank accounts of Mr. Zulfikar Ali Islam present till next date of hearing, that may be regularized.
The district magistrate and collector, Purva Mendipur. Filed in court today, be written with the records. Stop. The report mentions that the report contains an investigation report signed by the Shomiti Accounts and Audit Officer, SDO, Holdia, Subdivisional Officer's Office, Holdia, the Additional Treasury Officer, Holdia, and the District Magistrate and District Collector, Holdia. Wherein it has been mentioned that no fines for regularizing illegal construction was found to be collected during the course of inspection. Stop. The erstwhile Executive Officer of Holdia Municipality, Mr. Zulfikar Ali, specifically submitted before the court that there are several illegal buildings under the Haldia municipality, and such constructions are regularized upon acceptance of fines. Stop. The submission of the erstwhile executive officer and the report of investigation filed in court today are at variance with each other. Stop. The Superintendent of Police, Purva Mednipur, is directed to cause an investigation with regard to the amount of fine which was collected for allegedly regularizing illegal constructions made within the Haldia municipality for the period January 20 till June 10th, 2026. Stop.
But apart from the accounted money, which is in the report.
Accounted money is different.
But that is the report, and that money is whatever money has been paid to the municipality, we have.
Yes, that is a very paltry amount. And the amount is so less that the municipality is not even able to provide services to its citizens within the area. Right? And this area is filled with illegal and unauthorized construction. Where is the money going? This is exactly the purpose of the investigation. Since you are here today, please advise your clients as to how it has to be investigated and what are the things that are to be found out. Where did the money percolate? Stop. Learned advocate representing the municipality submits that upon detection of unauthorized construction, notice under section 218 of the West Bengal Municipal Act has been issued. Stop. 1 month's time has been provided to the persons responsible for making unauthorized construction. Stop. The said period is yet to be over. Stop. Next. In view of such submission, release the matter for further consideration on 24th of September 2026. Stop. An updated report from all the parties shall be placed before this court on the adjourned date. The report of investigation by the Superintendent of Police, Purva Mednipur, shall also be filed on the adjourned date. Stop.
But it has to be investigation by the police. There has to be a specific case. Then only the investigation can continue. So let it be an inquiry for the time being.
Acha, inquiry. Acha. All right.
But personal appearance of the contemnant may be dispensed with.
All right. Personal appearance of the erstwhile executive officer of the Haldia municipality, Mr. Zulfikar Ali, who is present in court today, stands dispensed with for the time being.
And according to para 14, my lord, my bank account.
Report submitted by the DMAB sub-documents.
But according to para.
Please give a copy to the petitioner.
And according to para 14 of your lordship earlier order, my lord, bank account was frozen. That may be regularized.
No, let it remain frozen for the time being. Let it remain frozen for 1 month. You please pass on the affidavit that you have given to the SP, to the learned counsel who is present here. That may be required. Copy of the affidavit of compliance filed by Muhammad Zulfikar Ali, filed in court today, has been handed over to the learned counsel representing the district magistrate.
I have already handed over to the petition.
Yes.
Lordship, I am appearing for alleged contempt.
Order which my lord have passed
of June 2026. Now, my lord, from paragraph 5 of my lord's order, Lordship had
What happened?
no action taken. No action taken.
SDO? Was it communicated to the SDO?
Communicate করে দেখেন। কোথায় এসডিও কে দিয়েছিস? না না এসডিও পেয়েছে সেটা কোথায় দেখাচ্ছে? And one thing more I should indicate to my lords, that my lord, after this order of my lords, they have filed an appeal before an incompetent court having no jurisdiction. Now, I was also searching under what provisions they are filing the particular appeal. Now, my lord knows, my lord, that under section 19, if there is an order of punishment, he has a right to prefer an appeal. Otherwise, a mandamus appeal. Now, that has also, my lord, have not been specified. Now, I say, my lord, no order of stay, no steps taken to hear her. Just it is a, my lord, card for showing the court an appeal has been filed. That's all.
Lordship, determination is not sitting, is bench. Appeal was filed, Lordship.
Nobody is there for the state over here. Find out somebody who's appearing for the state. See if somebody is there outside. Mr. Rasdeep Mozumdar was here. Is he outside? He must have left. Please find out. Please find out somebody. I'm passing it over for the time being.
I'm grateful.
Please wait, okay?
Yes, yes. I'm duty from.
132, my lord, I am appearing for the applicant, my lord. This is my lord affidavit of service, my lord, be kept on record, my lord. My lord, kindly come to the order at page 22, my lord. In portion 23, my lord. And in terms of the said order, my lord, I came to know from my client, my lord, on last Monday that the headmaster informed them that the rectification record has already, they sent to the district inspector of school for taking consequential steps. But
till now, no steps have been taken.
But district inspector school has not yet been taken any further steps, my lord. So, my lord, I have made my lord as a contemner, my lord, head of the institution, but district inspector of school should be as at condemner, my lord.
You did not implement the DIS party in the
No, my lord.
Why?
Because, my lord, before filing this contempt application, my lord, headmaster was not taking any steps, my lord, for.
I understand.
That's
but
why
now
my-
headmaster has taken steps.
Yes,
now
my lord,
it is
during
pending for
pregnancy.
the DI.
Yes, my
You
lord,
should
that
have
is the problem.
implemented the DI as a party previously. One by one, if the steps are not taken, will you come? You have to come up with your case in one go.
My lord, kindly give me, my lord, liberty. My lord.
Please come. On a perusal of the order dated 27th January 2026, which is complained to be violated, it appears that direction was passed upon the school authority and also upon the district inspector of schools for taking steps. Stop. The learned advocate for the petitioner submits that though the school was implemented as party, but the DI was inadvertently left out. Stop. Prayer has been made to to grant leave to the advocate on record of the petitioner to implement the DI as party contemptor in the instant contempt application. Stop. Leave sought for is allowed. Stop. Let the DI be impleaded as party in the instant contempt application. Stop. Let a copy of the contempt application be served upon the. But have you made any allegation against the DI? No. Then how will it
In
be?
this contempt application, I have not mentioned, my lord.
Then
As my lord,
how can you cure all the defects? You cannot do it. Then you have to file another.
fresh.
হবে না লিখুন তো show that the school has forwarded to the DI. Show
That is regarding that no copy has been, my lord, sent,
বাদ
my
দিন
lord.
ওটাকে কাটুন আপনি লিখুন যে none appears on behalf of the
And my lord, my respectful
contempt
submission
despite
before your
service.
lordship, my lord, kindly, my lord, direct the head of the institution to appear, my lord, personally, my lord, so that he can, my lord, produce the record that all the rectification record has been sent to the district inspector of school, my lord.
You send it to the secretary of the managing committee. And he is
He
the
is also the, my lord,
judge.
yes, not TIC of the school, my lord.
আচ্ছা none appears. So where is the notice? There are that contempt will be issued against Prabhash Kumar Mondal, returnable on 17th of September. Give the Passover matter once. I was, yes. An order has been passed in this matter on the last occasion where there was a direction upon the subdivisional officer for looking into the matter. Nobody is here for the state because these are contempt matters and state is particularly not a party, right? And the SDO was also not a party. It is the court who directed the SDO to take steps. Since no one was there and I found you, so I requested that somebody should be here. Either you can take it up, you can send somebody else also, no issues. Please hand over a copy so that he can pass it on. And
by today, I'm
yes, no issues.
Keep the matter next week. I shall take necessary instruction and come
Not
back.
next week, I'll give you time.
Lord.
Come back. Please come.
ঠিক আছে সবগুলো আমাকে একবার বুঝিয়ে দাও।
Affidavit of service filed in court is taken on record. Or presence to লিখে নেবেন। হ্যাঁ, আচ্ছা the
ওকে কিন্তু কোন সকাটা
learned senior counsel representing the petitioner submits that despite service of a copy of the order dated 18th June 2026 upon the SDO Baruipur, no steps have been taken by the said authority. Stop. Paragraph. Let a copy of the let copy of the contempt application along with all supporting documents be served upon Mr. Rajdeep Mazumdar, learned double AG or triple AG? Double AG.
Not triple.
Acha. Double AG for transmission to the SDO Baruipur for compliance. ঠিক আছে? Release the matter for further consideration. 17th of September.
And one thing more, I should indicate to my lords that after passing of this order, I find, my lord, that the Pradhan on 15th of July and 22nd of July passed these particular orders.
She passed orders? Would she? Strange. What order?
Kindly see, my lord.
তাও বৈধ 22 সালে কি বলেছে যে
Administrative তো কোনো কথাই শুনি না।
15th of July,
Yes.
notice is given
This order.
that the construction is unauthorized. Stop work is also given. সম্পূর্ণরূপে বন্ধ রাখার উক্ত জমির আসল কাগজপত্র নিয়ে আসুন. Then 22nd also, it is the same thing. Let her do whatever she feels like. I will not interfere in any of her activities, and she is not required to remain present.
Very good.
Hmm.
May I take the paper?
Yes, yes.
কবে ফিক্স হল? দেখতে আছে। বিপ্লবলেশ।
Yes.
My lord, I beg to appear on the petition. My lord's order has complied. Petition got the
Complied?
family bench.
All right, complied, disposed. One 34?
My lord,
Yes.
134, my lord, I am appealing for the petitioner. Lord, in pursuance of your lordship's order, my lord, we have served the learned government pleader, my lord. This is the affidavit of service, my lord. দিয়ে দাও ওটা। Lord, this is an application, my lord, for restoration, my lord, recalling the order dated 3rd November 2016. Now, my lord, within 8 days, my lord, the application was filed for restoration of the matter. And, my lord, the grounds which was taken, my lord, that due to illness of the learned lawyer, he could not appear, my lord, at the time of call. No accommodation was also called for, or, my lord, paid for. So, my lord, the matter was dismissed for default. This is, my lord, the main matter is with regard to, my lord, appointment to the post of Group D under the high.
It's a matter under the heading motion on until listener. সোমবার দিন দিয়ে দিন. Monday. Next Monday, it will appear as motion.
Yes.
Please serve further notice upon the learned advocate who is representing the state
No, my lord,
respondents.
notice we have served, my lord, in pursuance of your lordship's order, my lord.
Nobody is appearing today. I do not see anybody. You give intimation to the learned advocate who has been engaged by the GP's office. Followed? Go and find out who has been engaged. Give notice to the learned
Your
advocate.
lordship has given them enough chance, my lord, in the last occasion, my lord. Your lordship.
I restored your matter.
Yes. This is for motion.
Yes, motion. It will appear on Monday.
September list.
Monday it will appear. Next Monday. Today is
Next Monday.
Thursday.
Next Monday, yes.
Will you come on Monday?
Yes, yes, yes. I must come, my lord. Your lordship has fixed the matter, my lord.
All right, please come.
There was 4 operations of my eyes.
All
One,
right, please
2
come.
here and 2 there.
Next.
নামগুলো দিয়ে দাও। I am grateful to your lordship.
Yes.
But this is my application, affidavit of service.
Application for dismissal.
Yes, my lord.
Depend upon
I'll
determined-
first, my lord, show how I have served, my lord.
Yes.
Because the learned advocate who was appearing for the writ petitioner, he refused. I sent it to the school by speed post. There is an endorsement.
School is the petitioner, headmaster.
Yes, delivered. My lord, page 5, it has been delivered. I have also effected service, my lord, on the learned advocate, Dr. Patro, appearing for the School Service Commission.
Dr. Patru is not available today. The headmaster, the petitioner is the headmaster.
My lord, kindly notices the cause title, the headmaster of such and such school, represented by Devobroto Kaur. This Devobroto Kaur has retired in 2024. The writ petition stands abated. The initiator is no more. And I'm suffering an interim order. I have a recommendation from the School Service Commission that has been stayed by this court. Lord, may I give another notice to Dr. Patro?
Submits that a copy of the same has not been served. Respondent number 6 directed to serve. Petitioner liberty to file. The matter shall appear. Parvez Hussain,
He has refused to accept.
but 2. He has refused to accept.
Lord, I have pleaded in my affidavit of service.
All right.
Lord, once the refusal happened, I sent it by speed post to the school, which has been item delivered.
Show me your service indicator too. Animesh Babu, service indicator.
Lord, please consider page 2 of my affidavit of service. I also went to serve a copy of the same to Mr. So-and-so, learned advocate for the writ petition on 7/8/2026. He refused to accept the same. Subsequently, I sent the same to the petitioner by speed post on 7/8/2026. By a notice by email dated 10/8/2026, written by the learned advocate for the respondent number 6. Well, I am the respondent number 6. The teacher in charge of the school was given intimation post mentioning, and Dr. Patro, learned advocate for the School Service Commission, was duly served by hand on 11/8/2026, post mentioning.
Just tell me what is the issue in the writ?
My lord, I have a recommendation which is at page 32 of my application, issued by the West Bengal Central School Service Commission. My lord, transferring me from the school where I am presently serving to a nearby school near to my residence. This is dated 8th of June 2017. My lord, I subsequently wrote at page 33 for releasing me so that I can join my new school. My lord, that release order never happened.
Why? There is a recommendation. Why will the release order not be given?
My lord, it was assailed. The recommendation was assailed.
All right.
And page 35 is the first limited interim order, followed by extensions. And the last extension says 2nd of August 2018, the interim order is still disposal, final disposal of the writ petition. Therefore, I am suffering an interim order since.
Ground of assailing is?
My lord, I let me be very candid. Possibly, my lord, in terms of the then rules, I was required to take a NOC from my school. I didn't.
How could the
I
recommendation
straight away
be made?
I straight away wrote to the school education department because I was not having a good relationship with the head of the institution. The managing committee was not there. There was an administrator. I straight away wrote to the school education department. The school education department recommended me to the School Service Commission.
Without the no objection of this?
Without the no objection, my lord. My lord, that recommendation.
There was a problem. All right, you served Dr. Patro once. Give a notice. Dr. Patro has not come today. If you can give notice to Ms. Supriya Dubey also, that will suffice. She is not here. I don't find her.
Lord, please take it up next Thursday. I'll.
All right, none appears on behalf of the respondents despite service. Stop. Release next Thursday. It is 20th of August.
My lord, the affidavit of service may be retained.
Affidavit of service is retained. Yes, next.
Lordship,
Your Lordship passed an order on the last occasion.
May I just assist your Lordship? What has happened in this matter, it was not a question of renewal of registration. This was enrollment. Now, what is happening is there's a technical difficulty, I'm told, that unless the result is published, the software does not allow enrollment. This is the difficulty. Here, there is an order of Honorable Court that the result is not to be published. Therefore, my clients have suggested, for the exigencies of the matter, if your Lordship fixes a date and hears out the matter, everything will be solved. If he is allowed, then Lordship, otherwise also they have said that as and when the court directs, we will allow enrollment. I mean, after the last date, extended period, as per the Honorable Court's direction. But this software difficulty is there. Result has not been published. The portal is not open.
What is the reason for non-publishing the result?
Lordship, there was the original interim order saying that he had not, his registration stood cancelled, and therefore he was allowed to sit for the 4th semester examinations, but without creating any equity in his favor and without the result being published. That was the order.
Your submission was that the petitioner doesn't have the prescribed
No, I said that this particular petitioner had improved his qualification. He passed out. He had the necessary qualification. But what had happened is when he had originally given the registration, there he had been shown to be failed. And the school did not send the corrected mark sheet where he is supposed to have passed. So according,
if the candidate has improved the qualification, then
Lordship,
there is a problem.
kindly hears out the matter. Lordship, I am in personal difficulty. My university insists that the matter should be heard, and if ultimately it goes in favor, they will do whatever has to be done. They cannot go against your Lordship's order.
No, that is all right.
But my personal, while going through the records, I have personally seen that he has passed from NIOS and he's improved his qualifications. But your Lordship knows how these officers operate. They have asked me to file my affidavit and hear out the Lordship fixes a date. I shall come before your Lordship and
tomorrow is the last date. Tomorrow is the
no, that will be extended. That will not create any difficulty. I am giving my
is the last
personal.
date.
No, may not be difficult, but then the candidate should not miss classes, and you grant provisional enrollment or whatever is required to be done.
Registration is not being affected. Registration is already provisional. Registration is already
Be permitted to take classes.
The difficulty is that there will be no record unless the result is published.
Get manual records. Please come.
Yes.
But Lordship fixes, may I just request your Lordship fixes a date for hearing of the matter?
Right now, this matter is not so very urgent that it has to be heard immediately. There are other matters. You can see the court is hard pressed for time. It has been brought to the notice of the court that court by the learned advocate representing the university that due to the software issues, a candidate whose result has not been declared cannot be permitted to enroll, cannot be permitted to be enrolled for the next semester.
For the 5th semester.
Because this is the fourth semester, the semester where he passes. The first and second and fourth are the semesters by which he passes into the next.
It is seen from records that the candidate has actually improved his qualification. The university is directed to maintain manual records for the petitioner and allow provisional enrollment so that the petitioner can continue with the 5th semester classes. The matter
after reopening, Lordship, any day after
is required to be heard. Only for ascertaining as to whether the provisional enrollment has been made.
Lordship, I'll give my assurance to your Lordship. He will not be disallowed from attending classes.
Kindly pass an order.
And the candidate is allowed to attend the semester 5 classes, release the matter on next Thursday, 20th of August. And the matter will appear for hearing. Hearing in আগের দিনে একটা order দিয়েছিলাম।
Milord, instead of Thursday, Milord, would your Lordship take it up on any other day? Because for personal.
Wednesday will it be all right? 19th?
Yes. No problem. No.
Friday?
Yes.
21st?
Yes.
21st?
Yes.
All right, 21st. A direction have already been given for affidavits.
Yes. But liberty to mention was there. So I was saying if your Lordship fixes a date.
No, come back. Let the opposition be filed at least. Then
I'll file it within the next 5 days.
It to be mentioned.
I'm grateful.
There is no other person.
Milord, the portal has also not been opened.
That's why I'm saying,
That-
that's the
that's my-
difficulty. That's why
All manual records will be maintained by the university
and the college, it's the
thereafter
college, the
had
classes will
cooperated
be
in the matter.
classes
taken by the college.
college. We'll just intimate the college that he should be allowed to.
Shumanto, the institute shall permit the petitioner to attend semester 5 classes after obtaining necessary clearance from the university. Our personal
That there is not a time for mentioning. Extremely urgent matter. I am a NEET qualified candidate. I'm a NEET qualified candidate. On 8th of this month, a notice has been issued. Giving option to all categories. Or sorry, on 11th, notice has been issued giving option to all categories to opt for afresh to select their category. So for
West Bengal.
in West Bengal.
Ah.
Now, except not EWS.
Hmm.
Now, I belong to EWS category. I want to opt for registration. I have to.
No, but then this has been done possibly for the OBC ones.
Millet,
EWS is not.
this today itself says that you have to produce certificate issued on on or after 31st March. That's the procedure. In every financial year, certificates are issued.
Yes.
This application for NEET was made on 11th March. So the certificate that I had obtained before 11th March is not applicable for this financial year. But in any event, EWS has to give this option. Otherwise, the entire purpose will be frustrated, because person who had certificate prior to 31st March of that year, the financial year, will not be applicable for this financial year.
Everybody knows that. The 31st March, previous to 31st March, it will not be applicable.
Yes.
So you must have made application prior there too.
I had applied for on
Yes.
11th March. That certificate is not applicable.
That will be issued for the year of this
On that
year.
financial, I didn't have that certificate. For this financial, I have certificate. It depends on the eligibility of that particular financial year.
Yes.
So
where is the problem?
Because I am now eligible for this financial year, and the notice itself says that you have to produce certificate for this financial year.
Yes.
And the last
Therefore,
date is the 16th.
Therefore, unless I be allowed to opt for EWS category, I cannot produce that certificate.
So what is to be done now?
16th is the
16th
last
is date. Before that, I have to apply for registration. I have to fill up the form.
File it. Leave the in. Is it affirmed?
No, yet to be affirmed. By today, I shall affirm.
Fill up here. Serve notice upon all the respondents, whoever are there. Yesterday, one matter was taken up. Similar.
Affirm kore.
Similar matter was taken up. EWS NEET.
Item number 6, in the morning, Lordship has pleased to keep it tomorrow. The contempt application. Lordship was pleased to orally direct my junior to serve Dr. Patro in the yes, but it's in the second SRST.
Oh,
Mr.
yes.
Can he takes up tomorrow, or
Yes. Somebody should be there.
I have ensured he's present.
Yes, no issues.
Because he is in respect.
No issues.
Come. Lord, I am for the applicant, Lord. Pursuant to Lordship's direction, I have served.
My Lord, I beg to appear for the SDO and SJDA, Shiliguri Jalpaiguri Development Authority.
Has the order been complied?
Yes, my Lord, it has been complied.
No, my Lord.
No.
My Lord, and the unauthorized portion has already been demolished, my Lord.
Kindly takes up the matter, my Lord.
Lord, may I
The
submit
order-
my report?
Order dated 22nd December, my Lord, page 15, my Lord.
Yes, the photographs are also annexed with this report.
My Lord, second page of the order, my Lord. Paragraph 3.
Why was nobody present on behalf of the SDO on the last occasion when the matter was taken up? And that is the requirement as to why the SDO was required to appear personally?
My Lord, SDO is not the competent authority in this.
Maybe.
But they should have appeared, my Lord.
Lord, I shall
Somebody
quote
should
from
have
the
been there
Yes, my Lord.
to at least intimate the court that the SDO is not the competent authority. Why was nobody there?
Yes, today the SDO is appearing virtually.
That was the reason as to why his virtual presence was sought for.
Yes, my
It's
Lord.
only when they are directed to appear that the report comes.
My Lord,
Otherwise, it
from
doesn't.
the act, I shall show that the SDO is the
Show me the order, please.
page, my Lord, 15.
Yes.
Paragraph 3. The person responsible for making unauthorized construction is represented in court by the learned advocate. Let a copy of the notice be handed over to the learned advocate, as the authority has come to conclusive finding that unauthorized construction has been made. The authority is directed to proceed to deal with such unauthorized construction in accordance with law at the earliest. Now, my Lord, kindly takes up the West Bengal Panchayat Act
I shall show, my lord, who is the concerned authority. My lord, section 23, subsection 5, where any new structure or new building or any addition to any structure or building is been or has been erected or made, as the case may be, in contravention with the provision of subsection 1, the permission granting authority shall refer the matter to the subdivisional officer concerned, who may, after giving the owner of such building an opportunity of being heard, make an order directing demolition of the building or a portion of a building, as the case may be.
Here,
by
the
owner.
permission granting authority is the SJDA
No, my lord.
My lord, may I submit?
authority.
My lord,
My lord, I am for the
Panchayat.
applicant, my
Now
lord.
kindly see
Panchayat is the
section
authority.
1. My lord,
No, my lord.
you have to apply in
My lord,
writing.
section 64 is
Panchayat.
applicable, my lord.
Section 23(1), Gram Panchayat. My lord.
Panchayat is your
Yes, they have
How
not
does
approached.
SJDA come in over here?
Lord,
No.
this is
My
not
lord,
under the
kindly
panchayat
please.
area, my lord. This is the
This is under the
development
Panchayat
area.
My lord, this is under
My
the
lord, section
Panchayat area, and
64, my
they
lord,
have
of the
not,
2008
they
Act
do not have the
clarifies this
permission to
position, my
grant.
lord.
They did not approach the Gram Panchayat for the required permission. Without
Submission
permission.
of SJDA is within the SJDA area and you say it's within the Gram
My lord,
Panchayat area?
that was in connection with the earlier order in appeal, wherein Honorable Justice
No,
Shilpa Sarkar
name the area in question. According to the authority, it falls within the
Gram
SJDA.
Panchayat. From the writ
Very well.
petition,
If that be so, then I'm going to dismiss.
No, my lord.
Such disputed questions, the writ court will not enter.
Yes, my lord. Kindly seize, the order is very much clear. The unauthorized construction has been detected. Now the concerned authority will demolish the structure. My lord, and
It has
the
been detected by the SJDA.
SJD has detected it. The
How could SJDA enter into a
My
Panchayat
lord,
area?
that is pursuant to the earlier writ petition which was filed. This is the second round of writ petition
So
which
what?
has been filed.
Second round, the
My lord,
area
but
will
the
change. Do not make all
My
these.
lord, the
no,
construction
no.
has been demolished, my lord.
The
My lord, we have
SJDA
filed an
was made a
affidavit of
party to
compliance
the
before
writ
this honorable
petition.
court, my lord.
There was a direction to file a report. My lord, they have just filed a report. They didn't say from the report that it lies under the SJDA, my lord. That the area lies under the SJDA. My lord, I have also have the copy of the report which was filed by the SJDA. Kindly seize that they have detected it. They have went to the house of the private respondent to serve it. They did not serve could not find her, and that is why they served the copy through email. Peruse the report. Nowhere from the report it was stated that the concerned area lies within the Siliguri Jalpaiguri Development Authority. It is a Gram Panchayat area, my lord. In a remote village of Lishupukri, my lord. How did the
My lord,
SJDA
kindly
come?
take the order passed by the district magistrate, my lord, pursuant to the direction of the honorable division bench.
Who are you representing?
My lord, I have filed an
Unheard of.
application, my lord. I was
Lord,
the
it is a
person,
contempt proceeding.
respondent
Matter has
number
been
5. I
disposed of.
filed a application, my lord,
They are
in
trying
the
to
writ petition.
Wait, let me hear. I cannot get
My
you.
lord, in
Who
the
are you appearing for?
My
Mr.
lord,
Singhal.
my lord, I am the respondent number 15. Respondent number 15 in
Matter
the
was
writ
disposed
petition.
of
I
in
have
their
filed an
presence.
application before this honorable court.
For
My
what?
lord,
Dilatory tactics, my lord.
the honorable
They have
court, Can 2 of 2026. My lord, I have submitted clearly that pursuant to the order passed by the district magistrate, an inspection was conducted and a direction was passed to demolish the structure, my lord. There was an indicated that was the illegal portion that has been demolished. Subsequent to my demolition, we have also submitted a compliance to the authorities, SJDA, that we have demolished the portion. Kindly look into it and then please give us the compliance of the order.
Lord, I have
So
My
you
lord,
are the person responsible who made the construction and now you say that you have demolished the unauthorized
My lord,
portion.
pursuant to the order of the district magistrate by its order dated 16/7 had held that SJDA is the authority and the height of the building is exceeding the plan. My lord, the height of the building has now been demolished. My lord, I filed a CAN application, my lord. Kindly takes the CAN
After
application
disposal, my lord.
once. Yes,
After disposal.
my lord, there was a direction to hear the parties and pass necessary orders. A notice was served upon me in the court by the learned advocate for the petitioner when the writ petition was disposed of, my lord. Pursuant to that notice, we appeared before the authorities. We have the hearing has been conducted. Thereafter, the indicated portion which was unauthorized has been removed, and we have submitted to that effect to the
This is an incorrect
authorities that we
statement,
have
my lord.
demolished the portion.
SDO
Kindly
never called
inspect
an
and
hearing. No notice of hearing, my lord. Let them show that they have called for a hearing.
my
Let
lord,
the
it was
SDO show.
served to me in the order, my lord, itself.
My
It
lord,
is
My lord,
reflecting
petition
the
it was
notice
not
of,
served.
my lord,
It
kindly
was not
see,
served upon the writ petitioner
my
only.
lord, kindly see the writ petition in the order dated, which is contempt is proceeding. During the hearing, the notice was served to the learned advocate. It is recorded, my lord.
No notice was served upon my clients, neither upon me, my lord. Absolutely incorrect statement.
My lord, kindly see it's
And I have,
recorded in the order itself.
my
My
lord,
lord,
and I
kindly
have
seize
the
the order.
timestamp, my lord, photographs along with timestamp. Kindly sees when and where building was demolished. It is still standing long and tall, my lord. Timestamp, along with timestamp, I have produced the photographs.
My
How
lord, the
much is
entire
demolished,
building
where
is
it
not
is
unauthorized,
demolished.
my lord. The
Still,
height
the
of the
building is
building that
standing, my
was
lord.
exceeding has been demolished.
Is it your case
The
that the whole
petitioner,
building is unauthorized?
Yes, they did
how
not,
can that
even
be?
the land conversion was not there. They have converted, not even convert, applied for
My
conversion.
lord, there is
Without
a provision,
conversion,
my
they
lord,
have
under section 4,
erected the building
4C,
without
subsection
plans.
6. You must read the law, sir. There is a provision for conversion ipso facto under 4C of
Lord,
Land
no
Reforms
post
Act.
facto sanction plan is permissible, my lord. Post facto
Not sanctioned
sanction
the
plan is not. My lord, I have a
and that was
judgment
existing.
of the division
There
bench.
is a sanction
Post
building
facto, my
plan. The
lord knows
authorities
very
have
well. Post
considered the
facto sanction plan is not permissible under the law. My lord, if they construct a building, then they have applied for sanction plan.
annexed the land documents?
Yes, in the writ petition, it was annexed.
All right.
The SDO
Which
till
page?
date.
Which page? Which page?
My lord, annexure P1, my lord.
E1 is the sale deed.
P2, my lord. I stand corrected, my lord. My lord, registered deeds, record of rights. My lord, these are all the documents which I had at the time of filing of the application, my lord. Page 68 onwards, my lord.
What is the address? Is it 7 decimal? RS Khotiar number 5, LR Khotiar number 227?
Yes.
What? Yes, please check and then say.
My lord.
My lord, the documents are delayed completely, my lord. I am not able to assist, my lord.
My lord, page 135. My lord, Rupni, classification of land, Rupni.
Page?
135, classification of land, Rupni. Reni, Rupni. 136, Reni, Rupni. Second column, my lord. How can they construct a building upon Rupni classification?
135.
Yes, 136, my lord. Rupni, classification of land. Second column, my lord, will find
Where
Rupni,
is the second column? It's an inspection report, 136.
of the writ petition, my lord, page
Writ
136.
petition.
My lord, I am having a copy of the writ petition, my lord.
No, I have a copy of the writ petition.
Page number 136. My lord, in bold letters, it is written with sketch pen, my lord, at the top, my lord. Page 136, my lord. Annexure P2.
136 is something else, my lord.
Yes, it's something
It is an
else.
My lord,
inspection
sorry, my
report.
lord.
My lord, it is not disputed, my
Yes,
lord.
My lord, page
We have
68. Page
clearly
60.
stated, my lord.
I stand corrected, my lord. Page 68.
Page
Annexure
68.
P2. Rupni. My lord, kindly go through the record of rights, my lord. My lord will find every classification is a Rupni land.
What does Rupni Sreni classification mean?
Rupni classification, it has to convert it into Vastu. Thereafter, it has to be constructed.
What does Rupni mean? Is it agricultural?
It is the
My
agricultural
lord, it
land.
is. My
Agricultural.
lord,
Absolutely agricultural
kindly
land.
goes through the order dated one, my lord, the order that was before the writ court, my lord, page number 131. The reasoned order passed by the district magistrate, my lord.
The earlier writ
Pursuant to the
petition,
order of the division
my lord,
bench.
my
My lord,
learned friend is entering into merits, my lord.
no, that is the order that is
Entering into the merits, my
that
lord.
is the order which the honorable court has directed to be decided in accordance with law. I'm just producing that, my lord. It's in the
This is not a hearing of the petition, my lord.
My lord, kindly takes first page. It may also be noted there are provisions for regularization of conversion subject to fulfillment of provisions under section 4C6 of West Bengal Land Reforms
Yes, they
Act.
will demolish the building, apply for classification, then I can construct the building. Provision is there. They will demolish the whole building, apply for classification, apply for sanction plan, then I can construct. Who is stopping them, my lord?
My lord, there is a plan already sanctioned, my lord.
No,
We
no.
have violated the plan. We have already demolished that portion, my lord.
No. My lord, photographs are before my lord. Which stamp?
I have No, the relevant portion is at 132, last paragraph, my lord. Considering all the observation and findings made by the team, it is evident that the land falls under SJD area. It was constituted as per notification number this. The Gram Panchayat is not the authority to give residential construction permission within the planning area of SJDA, according to West Bengal Panchayat Samiti Rules
My
64.
lord, earlier there was a writ petition wherein it
My
was
lord, kindly
detected
cease.
that
My lord,
they have.
let me just go through. My lord,
Both of you speak together, the court will not be able to hear anybody.
My lord, may I
My lord,
submit?
64,
No,
Rule
don't submit.
64
You've
has been
submitted a lot.
reiterated, my lord. My lord, Rule 64 has been reiterated thereafter. Nothing withstanding anything contained in foregoing rules or in the West Bengal Gram Panchayat Administration Code, any area falls under a development authority, my lord, such area shall be deemed to be an area of development authority, and erection or construction of the structure or building within such area shall be governed by the related act as so far as the rules is framed. Now, my lord, the DM has come to the finding. After verifying relevant documents and observations made by the committee, it is evident that the land falls under SJD area. As the undersigned is not the appropriate authority, as per the West Bengal Town and Country Planning Act, the Chief Executive Officer is the competent authority. Necessary penalty should be imposed by the SJDA for such construction without permission, as per Section 52(1) of the West Bengal Town and Country Planning Act. Planning and Development Act. Necessary action shall be taken by SJDA by issuing notice to the alleged persons under Section 53 of the Town and Country Planning Act. My lord, on the date when the risk petition was disposed of, that notice was served through me to my learned to the clients, my lord. Subsequently, they have been heard, the documents have been produced. The land classification is now being converted as per West Bengal Land Reforms Act. And SJD has imposed a penalty for the construction without permission, my lord, at that relevant time. And my lord, that a reason order for after demolishing the indicated portion, we have given our report, our submission to the representation to the SJDA, stating that we have demolished whatever was indicated to us. Kindly inspect the same. My lord, this was done. Pursuant to that, we are waiting for further notices from SJDA. My lord.
My lord, if I may, my lord. My lord, may I?
No, don't
Lord,
submit. Please don't submit. Let me look at the papers.
My lord, kindly takes up
Let me
one
look at
page.
papers.
One page. my lord.
Don't make
Page
any
16
submission.
order of the division bench, my lord. It was detected by the division bench. There was no plan.
Do not make submission.
three courts have held that they have constructed without a sanction plan. Three courts, my lord.
अपने कार्ड में प्राइवेट रेस्टोरेंट
But my lord will kindly look into the first order passed by Justice Rajabasu Chaudhary, my lord, wherein again it was detected that they have constructed.
Wait a minute. You allege that the order dated 22nd December 2025 has been violated. This is your submission. The order in the writ petition was passed on 22nd of December 2025. Please check up.
22nd December 2020.
Right.
Yes.
Now, this order, when this order was passed, the court took note of the order of the DM 16th of July 2025.
My lord.
DM and collector, where there is specific observation that the land falls under SJDA. It was under this premise that the writ petition stood disposed of. And the court directed that the hearing shall be given. Notice was handed over. The notice was not received by the person responsible. The court directed the person responsible to be given an opportunity of hearing.
Yes.
And the matter to be disposed of.
Yes.
The hearing has been given, has been accepted by the person responsible, and then thereafter it has been demolished. Now the demolition, according to you, is not
In
proper.
accordance with law.
Then there is a fresh cause of action.
No, my lord.
Absolutely.
This is, my lord, this order, 17th of July 2025, is pursuant to the direction passed by the Honorable Division Bench.
The
Now,
court is not going to look into it. Please come.
my lord,
this is a contempt application.
but at least
you
that
state report of
hearing should be
compliance?
given, my lord. Compliance report, nothing has
By
been called.
the
I
give
was not,
copy of the compliance.
nothing has been.
That will be given.
My lord, I shall
Compliance
serve.
report.
That will certainly be given. A report of
My lord,
compliance.
may I submit the engagement letter as well?
Engagement letter means?
By SJDA and SDO. I
What
filed the
does
Vakalatnama.
engagement letter
My
mean?
lord, they have authorized me to appear in this matter on their behalf.
A formal vakalatnama is required.
Sir, Vakalatnama is being filed in the department, and apart from
Obviously.
that, an engagement.
No, the court is not concerned. You file it in the department, whatever it you've got to. Report of compliance.
That's a hard copy.
Signed by the
905
subdivisional officer, Shiliguri subdivision.
513175.
So it mentions that The unauthorized portion of the building which was detected has been demolished by the person responsible in conformity with the permissible building parameters as stated by
961.
SJDA
9-1.
in its report dated 5th August 2026. Stop paragraph. According to the petitioner, comma, the demolition is not in accordance with law. Stop paragraph. Photographs have been produced before this court in support of the submission that the construction in question still stands. Stop. The construction has been made over a plot of land which is classified as Rupni, RUPNI, i.e., that is agricultural land, and no construction could have been made thereon. Stop. Conversion, permission to convert the classification of land has not yet been obtained. Paragraph.
My lord, will also make it clear, my lord, under which SJDA, if the building falls, who is going to demolish the building, my lord?
SJDA will demolish.
My lord, SJDA do not have any rights to demolish the building.
Very well. It is up.
Only the concerned
It has
authority.
been demolished by
Yes,
the concerned person.
submission has also been made that the land falls within the panchayat area, and SJDA does not have any authority to deal with any construction made over the said plot of land. Right? Paragraph. The court is of the opinion that all the aforesaid issues raised by the petitioner cannot be gone into or adjudicated in the contempt proceedings. Stop. It will be open for the petitioner to approach the competent forum for redressal of their grievances in accordance with law if so advised. Contempt application stands disposed of.
I'm grateful, Your Lordship.
Application in view of the disposal of the contempt application, comma, any connecting application filed in connection with the same shall be deemed to have been disposed of.
My lord, my application is in the writ petition, my lord.
In the writ petition, not in
My
the
lord.
contempt. Nah,
My lord, I am not a party in the contempt, my lord.
then kishan application.
After disposed of, they have filed.
My lord, I have filed an affidavit of compliance before the court by way of
What
can.
is can 2?
My lord,
Can
that is my affidavit of compliance that we have complied with the direction, my lord.
by can 2 you file an affidavit of compliance?
My lord, we have filed an affidavit of
SDO will
compliance,
file
but it is numbered as a can, my lord. My lord, compliance of the order passed by the Honorable Court in writ.
My lord, and kindly record the SDO is the concerned authority for demolition.
No, it was already observed in the writ petition.
The compliance report has been filed by the SDO himself at a personal appearance of the
My lord,
SDO
along with
stands
SGDA as well. My lord, it is
Record
attached
his
together.
name. What is the name of the SDO?
Vikas
Lordship,
Sunil
this will.
is present.
Please put in your name in the
My
chat.
lord,
box so that
contender
the
number
proper-
4.
His name is there?
Yes, my lord.
Contender number 4. Check the spelling. All right. Call the next matter, please.
Deeply obliged, my lord.
Disposed. Yes. Dismiss for default.
Yes, Lord. Lordship, I am for the petitioner, my lord. For recalling application, my lord. Recalling of the order dated, my lord, 11 July 2023, my lord, passed by the Honorable Justice Aniruddha Rai, my lord. I have grounds stated in paragraph, my lord, 5 and 6.
What is the matter about?
Matter relating to, my lord, assistant teacher in charge. Teacher in charge, due to mismanagement of midday meal, my lord, He was in jail custody, my lord, 6 months.
Then?
Then, my lord, 6 months salary has been withheld.
You must have got the subsistence.
6 month salary has been withheld, my lord.
You must have got the subsistence allowance.
Matter has been referred to my lord West Bengal Board of Secondary Education. Not yet taken any decision till date.
Restore করুন. Let copy of the writ petition be served upon the respondents. Release the matter in the monthly list of September. Can disposed.
I am applying for the petition. May I please your lordship? Lord, this is for recalling. I can see only one minute the order, page number 15. The appellate court order. Page number 15. Relevant portion, only
Page number 15
51.5 of the can 3.
of the can 3.
Can 3. খুলে খুলে দাও খুলে দাও।
এটা দিন তো ওনাকে পেজ নাম্বার 15টা বার করতে বলুন।
হ্যাঁ কথা
What?
Not paginated.
Then put in the page numbers immediately.
No.
What is your submission?
Lord, that can you see last page? That is
Of the order?
Of the order.
Yes.
Lord, the writ petition was dismissed. First writ petition was filed. Thereafter, second writ petition filed, and second writ petition was dismissed with the order passed by the Pratik Prakash Banerjee that the first writ petition will be taken up for hearing. First writ petition was taken up for hearing and sent to the DI for taking decision regarding died in harness consideration. That is rejected. Against that, the third writ petition was filed, but by the impugned order that was with the misleading statement that no, in self-same cause of action 1, 2, and 3 writ petitions are actually not that. Against that, the appeal was preferred, and the appeal it is stated the last page that no, the last page of the page number 5, last page. In view thereof, the order impugned in the present appeal is set aside. That is, Lord.
You
In
didn't
view.
paginate it.
Oh, I'm giving you, Lord.
I can see the facts of the case is recorded over here. You filed the first writ petition 2016
My lord, against the rejection order.
seeking compassionate appointment.
No, rejection.
You again filed in 2018.
My lord. Since the file was not available, that is second
How
time.
do file is not available? You on the self-same cause of action. You filed a
Almost to depend separate representation, that is not the first cause of action. That is not the first cause of action. That's why in the second petition dismissed with the direction to pay cost, and to first petition will be taken for hearing.
And the where is the cost paid? Where is the receipt?
Paid. That is admitted fact. It is also that.
Receipt. Where is the receipt? There is no receipt. The court has recorded.
It was in the receipt of the appeal. Record of the appeal. That was there. Admitted, it is received and paid. On the basis of same, the first petition was taken up for hearing. And it was sent to the DI for taking decision, that is rejected. Against that, the third petition is filed. Third petition also that is dismissed with the view that no, for the self-same cause of action, first, second, and third is filed. But third is filed against the rejection order, first cause of action. Thereby that the appeal was preferred in the self-same not cause of action. That is page number 5 of the order.
that is the relevant portion, that is 4 lines. In view thereof, kindly see page number 5.
I have seen.
Well, there was also, as the time to exchange pleading in the third writ petition as directed by an order to such and such has expired, and as no affidavit has been exchanged, we direct in appeal court directed the in the third writ petition the respondents to file the affidavit in opposition within 3 weeks from date and representative within after long vacation. But the without order, the that writ petition cannot be heard. In that view, this can has been filed, so that the third writ petition can be heard afresh. Presentation করা হয়েছে? That is writ petition number 3821, page number 2, bottom of the order, 3821 of 2021. Madam, kindly be directed, pass direction that the same may appear in the as motion on any day on the daily list, so that I can serve afresh.
It was your prayer was rejected as you failed to meet the income criteria. You failed to meet the income criteria.
No, income, yes, merit. Yes,
Merit.
yes. Yes, merit of the writ petition. Rejection. On the self-some cause of action, my lordship's on judgment is there of this 2026 in July. So may I hand over that? It is a pat on the point, my lord. A self-some cause of action. Ditto self-some. That criteria.
Please come. None appears on behalf of the respondents. Let a copy of the writ petition along with the connecting application CAN 3 of 2026 be served in the office of the learned government pleader. Release the matter for further consideration on 14th September 2026 under the heading motion.
Along with writ, I shall.
Yes, it is with the writ. Motion হিসেবে আসবে.
Much obliged. My humble prayer, my lord. The original writ petition should have to come under the motion, since the in view of
I
the
have
order.
elected motion.
Yes. All right.
No. Motion. It will come under motion.
Motion. Much obliged.
This is my application for modification. Your lordship, kindly straightaway come to page 17.
Pradeep, dismissed for default and it was dismissed on merits. Yes?
Kindly straightaway come to page 17 of my application. This is an matter where I paid for
the application.
lordship. Modification application is there. That is CAN 1.
Anish Babu?
Up HRA. Now, initially, when I moved this matter, Well, at page 17, the
17, yes.
yes, well, kindly see the last two line why I am before your lordship.
Yes.
Well,
Liberty
parties
to
are
mention.
liberty to mention the matter after disposal of the said appeal. That is the motion Vishwas judge appeal preferred against the motion Vishwas judgment. Subsequently, several orders have been passed. Even your lordship have also passed an order where my lord, there was a direction to payment the HRA. Even this coordinate bench has passed an order subsequently, that is at page 18, where his lordship was pleased to direct my lord the respondent authority to disburse the HRA with 6% interest. Now, unless and until your lordship will modify this portion, I cannot move the writ petition. That writ petition is pending.
Modify which portion?
Unless and until the appeal, the last two line of the page 70.
Appeal has been
Still now
dismissed.
pending.
Appeal is pending. Dismissed.
Dismissed. So, now, kindly takes up the writ petition. Your lordship can dispose of the writ petition even today also.
In the absence of your other side, I can.
But I have served. Notice.
Application for recalling or modification. It was filed 24th. You have the order of the appeal court.
Yes, my lord, I have the order of the appeal court.
Please come. The writ petition has been filed by a teacher alleging non-payment of house rent allowance in her favor on the alleged ground that her husband receives HRA from his employer. This is the ground?
Ground, my lord. And
Is there an impugned order passed? Is there an impugned order?
Your lordship.
Challenging.
No, my lord. No impugned order has been passed, but page 40, your lordship kindly takes up,
Page
which shows, my lord, since February 2019, my HRA has been stopped.
Our HRA has been stopped since February 2019.
Lordship.
Stop. February. The writ petition was taken up for consideration by the court on 18th January 2023. এইটার আগে আপনি একটা প্যারাগ্রাফ লিখুন যে learned advocate for the petitioner relies on the judgment passed by the court on 16th March 2021 in a batch of writ petitions, first of which is WPA 1389 of 2018, Moshumi Biswas and another versus State of West Bengal and others. ঠিক আছে? The writ petition was taken up for consideration by the court on 18th January 2023, and as it was brought to the notice of the court that an appeal was filed against the judgment passed in the matter of Moshumi Biswas within bracket Supra, accordingly, the court adjourned hearing of the writ petition by giving direction for filing affidavit in the matter. Stop. Liberty was granted to the parties to mention the matter after disposal of the appeal. Stop. Paragraph. Learned advocate for the petitioner submits that the appeal filed against the said judgment stood dismissed on 4th December 2025, being FMA 654 of 2023. State of West Bengal and others versus Mita Mojumdar and others. একটু চেক করবেন তো মিতা মজুমদার এই লটেতে আছে কিনা। প্যারাগ্রাফ। এবারে as the issue has been decided, আমাদের এইচআরে যে অর্ডারটা আছে সেইটা দিয়ে দেবেন। ঠিক আছে? Writ petition, connecting application, দুটোই disposed. All right, disposed.
Lordship.
The writ and the application both.
I'm grateful to lordship.
Amen. এটা কলেজ নয়।
I'm grateful.
But I am for the petitioner, my lord, in this matter. But I am praying for a 1 week extension to file the exception to the report filed by my learned friends.
You are the petitioner?
And the petitioner, my lord. 1 week time, man.
You are for?
Municipality.
What is your submission?
While for the demolition, the infrastructure has not available to the municipality. That's why the further consideration for further consideration this matter for to SG.
My lord, in this matter, my lord, they are municipality. They have conferred the matter to the SDO, my lord. But in case of municipality, my lord, the SDO doesn't have any power, my lord. On the report, they have said if my lord kindly sees.
We have no
Municipality?
Joynagar Mujilpur municipality, my lord.
do we have no infrastructure?
You do not have any infrastructure.
That type of infrastructure for
How big
demolition.
is the construction? How big is the construction? How big is the construction?
Lord, it's a two-storied building.
Two-storied building?
Building.
Completely unauthorized?
Unauthorized, my lord.
Completely
Unauthorized. They have said it, my lord.
It's saying for further consideration to the SGU for arrangement demolition process. In the report, my lord, in the report para last line.
They said that there is a deviation in the construction.
The affidavit of compliance, is anybody leading you? Are you handling the matter independently or is anybody leading you?
My senior is leading.
Where is your senior?
He is in another court. That's why.
Another court? Please call him. All right. Tell him to come. I am passing over the matter for the time being.
Well,
I am for the petition, Lordship. My lord, I filed the restoration application, Lordship. Can number 2 for restoration of the can 1 and main petition, Lordship.
And your reason for non-appearance?
My lord, that day the learned advocate was busy in another court, Lordship.
That is not a ground. Your matter is being taken up here and the learned advocate remains busy in some other court is not a ground for restoring the writ petition.
Kindly restore it.
Is anybody there?
I appear for the municipality led by Mr. R.N. Chakraborty, Your Lordship.
Yes.
Your Lordship, in this contempt matter, it has already been recorded by Your Lordship on 19th of September 2024 that the order has been complied with. Subsequently, they had filed a CAN application wherein they had prayed for the implementation of the order dated 19th of 24. Your Lordship, I've sought for instructions, Your Lordship, further inform the municipality. I'm awaiting those instructions, my Lord.
Not for instruction.
Yeah, Your Lordship, it has been complied with since the matter is again coming up. So I've
The order has not been complied, you say?
I don't, no, my lord. They have not complied the order. That's why I filed this contempt application, lordship.
Pradeep? Restore.
And I already communicated the concerning department, lordship.
Department? Which department?
Chairman, sub-agent, engineer, and the district magistrate, subdivisional officer, Alipur.
It is under the which municipality?
Mahesalam municipality.
Then what will the
Chairman.
DM do?
Chairman of the municipality.
Municipality is represented.
Yes.
The learned friend is there for the municipality.
But they did not comply with the order.
Which order has not been complied?
Order dated 31st/7/2023, lordship, and repeated reminder. And
21st or 31st?
31st.
31st of July.
July
of 2023.
And 23
19/9/2024 also.
9.
The 19th of September, it is recorded that the order has been substantially complied with.
Sir, lordship.
order comply হয়েছে বলে সাবমিশন করে দিয়ে That was false submission, lordship, as per instruction.
Learned advocate for the petitioner submits that. The municipality. No, that wrong and incorrect submission was made on behalf of the municipality solely for the purpose of disposal of the contempt application. Specific case of the petitioner is that the order passed by the court on 31st of July 2023 has not been complied with. Paragraph. Learned advocate representing the municipality seeks time to revert with instructions. Let an affidavit by the chairman of the municipality be prepared and circulated by 11th of September. Release the matter on 24th of September. And 2 gets disposed.
Grateful, lordship.
কোনটা রেস্টোর হলো একটু দেখবেন। Is anybody there in the Passover matter? Passover matter kyun nahi? Not today. Call the first day's matters.
My lord, my senior Sudarshan Kaushik, my lord, left the court, my lord, due to illness.
Now illness. I'm making it not today. Come on the next day. Come on the next day. In the meantime, you prepare whatever you've got to prepare. Yes, 368. 368. আরে Passover রাখুন।
Decision and I am for the applicant, my lord. This is the first time contempt application, my lord. Order dated 18 November 2025, my lord.
All right, please serve. Who is the contemptor?
My lord, DI Purbo Bardhaman and
One.
ADI. One, sorry, my lord, Purbo Mednipur DI and ADI Purbo Mednipur and school, my lord.
School is also a
Yes, my
contempt.
lord.
Why? What is the school supposed to do?
My lord, the order paragraph number 6, my lord. 7, para 7, my lord. 7 and 8. The school is directed to render all cooperation to the DI and the ADI of school of implementation of the direction first herein above.
You have made DI and ADI both parties?
Yes,
Only
ma'am.
the DI.
No, my lord. DI 1 and ADI 2.
DI 1, ADI 2. DI, ADI. All right, serve notice upon all three.
Grateful to your lordship.
List on the 24th of September.
Grateful to your lordship.
My lord, I am for the applicant, my lord. My lord, they have violated my lord's order dated 6th August 2025 at page 138, my lord. At page 138. 138. My lord, ordering portion at 140, para 13. Direction was there. If appears that the private land of the petitioner has been utilized for public purpose, then necessary steps for acquisition of the same in accordance with law shall be taken. But they have not initiated any steps regarding acquisition.
What has happened? The pipeline has been laid?
Oh, no, pipeline already laid when the writ petition was pending, but they have also constructed concrete part over my private land. Both the petitioners are senior citizen and they have no power.
You have made the Pradhan a party?
Yes, my lord, I have made for a Pradhan.
But the direction was upon the BDO, isn't it?
No, my lord. Not video not. Or BLRO.
To ascertain as to whether BLLRO.
BLRO, yes.
The concern is directed to cause a spot inspection upon. Where is the BLRO? You've not implemented the BLRO as a party?
No, my lord. BLRO has made the inspection.
Has made the inspection?
Yes, my lord.
Given the report?
Yes, my lord.
What does the report say?
No. They have not given report, my lord.
Then?
They have made inspection, but they have not given report.
You will not make the BLLRO as a party?
No, my lord, because my violated construction was made by the Pradhan, my lord.
The court directed the BLLRO to find out whether the land is yours or it was a Gram Panchayat land. And you did not make the BLLRO, but you implead the BLLRO as a party. Do you know the name?
No, my lord.
Find out.
My lord, liberty may be given. I shall.
The petitioner alleges violation of the direction passed in the order dated 6th August 2025. Did you make any allegation over here against the BLLR or nothing?
No, my lord.
Then how will you add him as a party without any allegation?
Only against Pradhan I have made because they have constructed.
There was no direction upon the Pradhan. The direction was upon the BLLR to ascertain.
They have made inspection, but why Pradhan has made construction? That is why I made party contender as Pradhan.
To implead the concerned BLLRO as party contender in the instant contempt application and serve a copy of the contempt application upon the added party. Stop. What about the land falls under 2 Gram Panchayat?
Yes, so far person my clients informed that it is the border point of the 2 Gram Panchayats.
Border of 2 Gram Panchayat?
Yes, madam.
It may be the border, but then under whose area does the land fall? You do not know.
Yeah, no, madam.
Let notice be served upon the contender numbers 1 and 2 also. Released 24th of September.
24, get full mark. Yes.
You inquire about the name.
Name, yes, my lord. I have.
Leave to implead.
I'm coming with one answer.
How soon can you?
My lord, kindly allow me only 1 day.
Yes.
After...
By tomorrow, can you do it?
Yes.
By 1 week. Kore din.
1 week. Get full mark. 1 week. Get full mark.
Yes. Next.
72, may I please, Lordship, I am for the petitioner. Here your Lordship's order has been violated. Your Lordship's pass an order on 23rd March 2026 directing the respondent authority to take steps for appointment. I have communicated this order, thereafter sent the by 8 weeks. My lord, I have communicated, thereafter contempt notice was issued, but till date they have not appointed. My lord, this is the with regard to the recruitment process of 2024. I am day by day losing my seniority and everything has been done. Now they will again after appointment.
What is the result? What is the result of the appeal?
All appeal dismissed, not dismissed. It was disposed of without touching the order passed by the honorable single
judge.
And the order already the issue has been settled by the honorable Supreme Court.
What is the issue over here?
Issue is that rounding off 169.5 would be rounded off.
All right, rounding off. I get it. The petitioner alleges violation of the direction passed in the order dated 23rd March 2026. Stipulate notice be served. Released on 10th of September.
10th of September. Deeply obliged. Much obliged.
Yes, next. $373.
Your Lordship's order dated 27th of January 2026.
First time coming.
First time, Your Lordship directed to the Commissioner of School Education to dispose of my representation in the higher scale of pay, taking into Utpal Kantikaran.
Not done.
Not done in the sense, this Commissioner of School Education passing the regional similar type, which was deprecated by the court in a similar type. I have
and
so this shall not be repeated. Your Lordship said, kindly take my Your Lordship paragraph 7, paragraph 23. And this court, in a similar situated matter, issued a contempt rule. Same stereotype order I have annexed.
Then I'll see today. There is no time. I have to rise. I'll make it not today only. Next.
May I have and come back? First time.
All right, serve.
Yes,
serve.
Come contempt.
24th of September. Serve.
I'm so grateful to you.
374.
Get
374, my lord, I am for the petitioner, my lord. My lord, this is appearing for the first time, my lord. My lord, notice be served, my lord.
Who is the contemner?
Contempt. I'm the, my lord, petitioner.
Who is the contemner?
Contemner, my lord. Contemner Nikhil. Nikhil Niramal.
I do not want to know his name. Designation. দেখে নেবেন একটুখানি 24th September.
Commission of School Education, my lord.
Commission of School Education. All right. 24th of September. Sub notice. 375.
375, my lord. The notice has not been served, my lord.
All right.
348 before at the first sitting it was mentioned, my lord, second time.
It was called on. Nobody was present. Huh? 378.
348.
348. What is it? What is
The
it?
restoration of electricity connection, my lord, after serving.
Your advocate on record should have been ready.
No,
It was inquired as to anybody was there or not. Nobody replied.
Get